Welcome back, everybody. We are continuing with Section 3 on violation cases. The next case is 2020-089. Will we please get a report on the case? We're ready.
Oh, sorry. Stupid thought, sorry. Case number 2020-089. The Office of the Secretary of State received a complaint that Ms. Marilyn Marks took a photograph of a voter list on August 11th, 2020, while at the Peachtree Christian Church polling location. Ms. Marks advised she was an unauthorized poll watcher and stated the following. Mr. Ware showed me the voter list. To my surprise, the list was dated June 9th, 2020. Attached as Exhibit A is a true and correct copy of a photograph that I took of the June 9th, 2020 voter list that Mr. Ware showed me. Mr. Ware was interviewed and advised that Ms. Marks did not ask permission to take the photograph. Per the conditions for inspection, Rule 34, page 6, states photographs, video, electronic and paper copies, and printouts of all documents related to activities inspected are permitted to the extent that they do not contain personal identifying information. Marilyn Marks admitted in the Declaration of Marilyn Marks that she took a photograph of a voter list at the Peachtree Christian Church polling location on August 11th, 2020. The photograph she took contains voter registration numbers, voter status, name, date of birth, residence address, and district combo. Potential violations are 21-413, subsection E. That's it.
Does the respondent want to respond? Is that it?
Thank you. The facts in this are very straightforward. Pursuant to discovery in the Curling case, Fulton County and my client agreed to a series of different inspections and are still in the process of doing this over the years of different voting equipment, physical equipment, access to polling places, access to documents out of the discovery process. As a part of that discovery process, we had a protective order, and the protective order made it very clear that personal private information was not to be posted with anything that was filed. Pursuant to our Rule 34 request, Ms. Marks and Hari Hursti were given access to the polling place at issue and allowed to take photographs, as was the agreement per the rule. It was a Rule 34 request to be able to do that. We took the Curling Coalition plaintiffs took the information that Marilyn Marks had obtained, and it included photographs of a ballot book. And the reason for the photograph was it was a part of our claim that the state needed to use updated to the minute backups for the poll books. It's one of our claims, and that what the claim that we were pursuing, Judge, was that the poll books go down so frequently and there's no backup to them. The state contended that no, there was a backup. We obtained evidence, and this is a part of that evidence, that the ballot are dated, that they weren't up to date. And so this was a photograph of the page of the ballot book, which showed its date, which is May, and the election was in August. We used that as a part of a lot of other evidence and actually obtained an injunction from Judge Totenberg that the state use properly backed up paper poll book backups. When I filed, not Ms. Marks, but when I filed our evidentiary support for our motion, I did not redact the column of the date of, my memory is, the date of birth of the voters. I was immediately notified, I believe, by the Secretary of State's attorney, one of them. I don't think it was Mr. Tyson, but one of them. I immediately pulled it, filed a redacted copy. Months pass, and then we are alerted to the fact that this is the subject of a state investigation. I then contacted Mr. Tyson, who was both myself and Mr. Ichter communicated, my co-counsel, Kerry Ichter, communicated with Brian Tyson. This was when this complaint was actually on the board's docket 2 years ago. It came up on the board's docket, and I contacted Brian Tyson and said, isn't this a discovery? First I said it was my fault that this was put on the internet, but isn't this a discovery issue under the protective order in front of Judge Totenberg rather than something that should be prosecuted by the SEB? He did, in fairness, I don't want to overstate, he did not respond to that. However, it was instantly dropped from the board's docket. And that's all I heard about it. That was 2 years ago. And then it came up again today. And so that's all we have to say. I would say that just a couple of points is, of course, the power of a litigant to obtain information under Rule 34 is far more extensive than the law would otherwise allow, or else you wouldn't need it. And we have obtained, and it is through the Rule 34 discovery that we even know about Coffee County or Treutlen County, or have Dr. Halderman's report. And so it was in the course of that discovery that this was conducted. A mistake was made. I made it. I fixed it immediately. Mr. Marks has done nothing either contrary to the protective order or to the law. And we respect the state investigator for pointing that out, but believe that it should be dismissed because this is a discovery issue in front of George Totenberg, not something for the board to consider. Thank you.
If I may.
Mr. Brown?
Bruce? I'm not, the discovery part in terms of accidentally and then redacting, that's another issue, but I'm more interested in, I understand the discovery side, but the poll worker isn't necessarily, the poll worker, and for that matter, the county isn't necessarily always privy to what the discovery is. So I guess my question is, was there a specific authorization from the county? In other words, you have the authorization from the judge. You have an agreement. Did anyone go to the county and get an authorization? That's what I want to know.
My statement of the facts was incomplete. The Rule 34 request was to Fulton County and their lawyers, Cheryl Ringer and others.
Yeah.
And that's who we dealt with. And we actually would negotiate with Fulton County over which polling location we could go to. So for example, in this one, there were five or six different locations. One of them was Peachtree Christian Church.
Yeah.
And we went back and forth on, you want this one, you want this one. So there was a lot of exchange between council. Also discussion about hours, when are you going to go, and that sort of thing. And so it was discovery to Fulton County, and they responded, and we negotiated the arrangements for when Hart Hursty and Marilyn Marks could go.
Okay. Was there any kind of, from the election superintendent or from the Fulton County Election Board, a specific authorization? That's what I'm looking for.
It was their lawyer, yeah. Yeah.
Well, let me, having presided as a federal district court judge myself, my guess is that Rule 34, you serve a request to produce, and there's a response by the respondent. And the judge generally doesn't get involved unless there's a motion to compel or a motion for a protective order. So I assume that didn't happen in this case. Is that correct?
There have been a number of motions to compel, et cetera. I don't believe this was subject to a motion to compel.
So
I'm
court-
not sure it hasn't. I'm not sure this one hadn't, because we had some very drawn-out discovery disputes with Fulton County. So
Can you
I-
represent to me here today as the counsel and been involved in this litigation that Judge Totenberg understood that information that you requested, that you were requesting required the violation of a state law?
Specifically, no. However, a lot of the discovery, if you didn't have a subpoena, would be in violation of law. For example, we got a server. When Dr. Haldeman got the machine, we've got this.
Well, I understand, but a subpoena is different from a request to produce under Rule 34. A subpoena is a court document that allows you to do certain things, and under compulsion of law, has to be produced. Did you have a subpoena to look at these and to photograph these voter rolls?
To a party, I mean, I defer to your better knowledge of the federal rules, but to a party, a Rule 40 request is the same as a subpoena.
No, it's not.
And so we served it upon the other party, and we
A
negotiated
subpoena?
the Rule 34 request.
Rule 34 request is under the Federal Rules of Civil Procedure. Under Rule 34, provides for discovery between parties in a civil litigation to exchange information, and that you do not require a court order or a subpoena to do that.
Right.
So, first of all, this judge never authorized you to go to a place and take a picture of something which was, in that picture, being in violation of state law. Now, if you lawyers decided that you had it within your authority to do that, which I suspect you didn't, it was Ms. Marks who was there with the county, with somebody from the county, and they asked somebody to engage in conduct that was a violation of state law. What I would expect, if I was somebody was in my courtroom, and I think any federal court judge would expect, and I suspect Judge Totenberg would suspect, that if somebody said, now look, one of the things that we want to do is we want to go and take a photograph of a log, and by the way, state law prohibits that photograph from being taken if it has individual information. Can we have permission to do that? You would, my guess is that she might well think well of that, or she might say, no, you can photograph it after the personal information is redacted. What I focus on in this, which by the way, the date of this report is 2021, so it is old, but it's not like it went away. It's been a matter under investigation. Regrettably, it's taken us a long time to get to some of these, but as of the report of 1/26/2021, the allegation is this, that Ms. Marks, as a litigant, went to a place claiming that she thought she had permission to to engage in conduct that violated state law. And that's a violation. And you can take responsibility for all of the other things that you should have done. I would say what you should have done is gone to the court and said, look, we're going to do this. My guess is you had no idea this was going to happen. And that Ms. Marks was there and she made the decision because she thought that as a litigant, she could, under Rule 34, at her understanding of it, that she never consulted with you and say, by the way, we're going to take a picture of that, is that okay? That you didn't know any of that. And I believe that to be true. And if it's not true, it'd be interesting to know that, but I don't think it is true. I think she engaged in conduct that violated state law, and that's what she's being charged with. And by the way, the next time you make a production or file something, there's a standing rule in the Northern District of Georgia where this case is pending, absolutely making it your responsibility to redact personal information. And for some period of time, that was public.
Absolutely, Your Honor.
And it's public because she took a picture in violation of state law. If she hadn't done that, we wouldn't be here.
Your Honor, the filing of the information ran at least 2 red lights. One of them was, even without the protective order, the rules require when you file something to make sure that there's no personally identifying information.
People get
It's
in a lot of
right
trouble
there.
for doing
It's
that.
right there on the ECF that says,
I know
make
it
sure
is.
you haven't done it. And so you're exactly right on that. As to the discovery aspect of this, though, I don't know if I disagree with much of what you said, except litigants frequently, with a document request to the state through Rule 34 or a subpoena, are allowed access to all kinds of information, data that they would not otherwise have privy to, including information that if they didn't have that authority, would be a violation of the law for them to obtain. We inspected scanners. We got under the hood of scanners. We did scanning tests. Won that injunction also because of what we found. Dr. Halderman got a copy of got the machine itself. He couldn't have done that by himself, and Fulton County couldn't have given that to him without violating the law, absent a court approval.
When that person took a court order, didn't the court order that, specifically order that?
For the Dr. Halderman, well, for all the gear, yeah, we got in discovery to fight over it, and Judge Totenberg, and we sorted it out.
Yeah.
And I don't know if it was ever an order, but we agreed to it.
You agreed to it, but that was a consent order, I think, signed by the court, meaning the court authorized you to do that because the position I think the state took was that it was otherwise a violation of state law in order to do that. They were not going to produce it pursuant to the regular rules under Rule 34 without court intervention, and the court intervened and gave permission.
Yeah, I don't know from my standpoint is, we serve a Rule 34 request. You don't need a subpoena for that. It's the same as a subpoena.
What is?
A Rule 34, all a subpoena.
It's not. No,
Your
it's
Honor,
not.
I can send a subpoena without a court order. A
It
subpoena
has to
isn't
be
the,
issued by the court.
under an auto pen by the clerk. It's not by the court.
Exactly, but it has to be issued by the court. It's different.
But it would, if we had sent Fulton County, I think this is moot, or not, is really beyond the point. Here's why. If I had sent a subpoena with that Rule 34 request, if that was wrong, it was wrong whether it had a subpoena or not. The subpoena, I think, is a red herring. The fact is, there was a discovery obligation that captured information that state law says should not be disclosed.
Well, let me try this because you don't answer questions very directly. If there had not been a Rule 34 request, would it have been a violation of state law for Ms. Marks to take a photograph with personal information of a voter roll?
Yes.
And you're saying that somehow that violation is excused because of the allowance under Rule 34 of parties to voluntarily participate in information. So you're saying that the state can voluntarily violate the law if they have a Rule 34 request?
I do. Things.
Well, I just think you're wrong about that.
Okay, but I mean, trespass is the
That's-
same
Well, it's at
thing.
least a trespass.
Trespass is illegal. If you're given permission, it's not illegal.
Well,
It's
I know.
not everything. All a discovery involves a potential infraction of state law, criminal trespass.
Rule 34 requests usually are exchange of information between lawyers. It's extraordinary for a client to go out and participate under a Rule 34 request to say, I'm the one that gets to make a decision on whether or not something can or cannot be accessed by me.
I mean, Rule 30, look, this is not a document request.
That's what Rule 34 is.
This,
Request for the production of documents, Rule 33 is a request for interrogatories.
no, this is a Rule 34 request for inspection of things. That's what this was. This wasn't a document request. This is an inspection of things. That's how we get the gear, is for the other part of Rule 34 that has to do with inspection of things. And no, lawyers are not the ones doing the inspection. Lawyers might be the ones getting the documents, yes, but not inspecting things like this one was. Well, I do think that's a difference.
If I may, Judge, question, and maybe even a comment, and I'll give you a chance to respond. I don't know if Fulton County, or even if Fulton County's lawyers, can waive state law regarding regarding whether or not someone can make photographs. I can see where a judge can. If quite frankly, if y'all had gone and said, we have this agreement, Judge, here, and part of what I'm trying to do here is sort of make sure that we set things up, because believe it or not, y'all aren't the only lawsuit that takes place on election law. And I kind of want to sort of make sure a roadmap gets taken out here, is that if there's going to be a waiver of state law, there needs to be a court order, not simply even two lawyers agreeing, or even a county agreeing, should that have taken place. Is that, and I do worry about that. I do understand, Judge Totenberg certainly would have that authority, and has exhibited that authority in other areas that we've discussed. But I do worry about lawyers or even a county waiving a state law or state prohibition. I just sort of throw that out to you, and I give you a chance to respond.
Thank you, Mr. Lindsay. I appreciate that concern. Going forward, my point today is that the respondent, Ms. Marks, with Hari Hursty, her expert, undertook this investigation of the polling place, which included taking pictures of the ballot books, with a very reasonable understanding that it was authorized, specifically negotiated by Fulton County at the specific location. And whether or not the Rule 34 request gave Fulton County the authority to do what they did, or I don't know, and it could very well be that in situations where, in situations like this, that it's better practice to get the court to order it, like we would have with the physical equipment. Yeah. I don't doubt that. But in terms of the respondent's responsibility for this, we believe that the charges should be dismissed.
Thank you.
Thank you.
Mr. Brown, Attorney Brown, I have a question, if I might. The same statute, the exact same statute says that no photography shall be allowed of a ballot or the face of a voting machine or a DRE unit while an elector is voting such ballot or machine or DRE unit. So your argument would have been that if she had taken pictures of voters in the act of voting or a ballot, that would have been okay too under this rule, right?
No, that would be wrong. I mean, I don't think I think that's actually a very good Socratic question.
No, it's a very good practical question, because you're saying an inspection lets you do whatever you want so long as the county lets you do it. I mean, you can't parse through this. I mean, I know you're making the best argument you can. I understand the advocacy, but the moment she took that picture, it violated the law. You're saying it's excused because she didn't know that and she thought she could rely upon what she was told by the county attorney.
Well, I do think that the fact that it was done pursuant to discovery and an agreement with the county should have an impact upon the board's consideration of the matter. I do. Mr. Mashman, I understand your point, and that consent has its limits in terms of the violation of the law, and it's not going to excuse it. And I also understand the admonition about the difference between a discovery pursuant to a court order and something that's done pursuant to counsel. The complexity of the litigation, I mean, I know we're not the only election case, but the complexity and the amount of negotiations that goes back and forth of these, perhaps sometimes the litigants believe they have more authority than they do.
That's why they have lawyers. Is there a motion?
Mr. Chairman, I would make a motion.
Find a technical violation with the letter from this board to go ahead and adjudicate it now. No further sanction, but I do think that we need to make sure that, not just in this case, because you guys have been going on for about 8 years, I may be off by a year or two, and you're probably going to go on for a few more, but there are about 20 other lawsuits that we have now as well. But I do think that we need to send out a clear understanding that anytime there may be a deviation to state law, that needs to be taken up by a court. So for that reason, I'd like to go ahead and have us go ahead and send that message now rather than send it to the AG for a further order. So for that reason.
So what's your motion?
Motion to find a violation and a letter of instruction.
Is there a second?
Second.
Any discussion?
One of the things that we do with letters of instruction is that we respond to issues where a person thought they were doing something that was okay, and we inform them that it wasn't. So that fits in what the board has traditionally done with letters of instruction.
And may I also add, Mr. Chairman, if I can, this is not just to, in this particular case, but to anyone who engages in litigation, because my next motion for the next time this sort of thing comes up, I'm going to send it to the Attorney General's office for a heavier sanction. But this should put on public record, folks, how things should happen. I do believe that the lawyers were acting in good faith. I believe that Ms. Marks thought she had authorization. Clearly she did not, however, underneath state law, but I believe that she was acting as believing that she did. For that reason, that letter of instruction, and we ended here, so that the parties then understand moving forward how such activity needs to be engaged in, not just in this case, but in any other case involving election issues.
I'm going to move to amend by striking with a letter of instruction and adding entry of a consent order that specifically provides, in the context of what we've heard is a very complicated litigation. The litigants don't know what they're supposed to do because it's so complicated, it's gone on for 8 years, that it needs to be clear that any time that they request information, that they get a court order in order to get the information if it would be otherwise a violation of state law.
Can we ask them if they would agree to a consent order?
What?
Mr. Brown, can y'all agree to a consent order?
The consent order would be that, and it's in the context of this litigation that you said has gone on for a long time, that the litigants, because there's been lots of activity, don't know what they can do and can't do. But what we know happened here is that there was conduct on behalf of a litigant that violated state law. You claim it should be excused, but because there's confusion with respect to the people that you represent, that the consent order would be that you agreed not to engage in this conduct again, and that any time you request information that is otherwise protected and prohibited by being made available because it would violate state law, that you will first get a court order.
I agree to that.
Don't we still have to send it to the Attorney General's office?
Yeah, then we'd send it to, in that case, I amend it to send it to the Attorney General's office to simply get a consent order between the parties as agreed to by the respondent in this matter.
So that's first, so you're amending your...
Amending, you are amending and I'm agreeing to.
I need everybody to agree to it. Does everybody agree to the amendment? If you,
Just to ask, did the court reporter get Mr. Brown's response? Okay, thank you.
So the motion now, with the now accepted amendment, is that we find a violation and that the case be referred to the Attorney General's office with instructions that we enter into a consent order be entered into between the board and the respondent, Ms. Marks, that provides that they will not violate the section of the code in the future, and that any time they engage in conduct in the course of this ongoing litigation, that it would be a violation of state law, that they they get a court order allowing the production of the information to be produced, that if not under court order, would be a violation of state law.
Thank you.
And our lawyer, Beth, is that appropriate for us to instruct you to do that? Good. All right, does everybody understand the motion? Okay, the motion's been made and seconded. Is there any further discussion? All those in favor of the motion say aye. Aye. Those opposed, no. The motion passes unanimously. All right, thank you. So, Mr. Brown, I know that when you're here, you make things a little longer, but you make them a lot more interesting, and it's kind of fun to be a lawyer again. What's that? Pardon me? I don't like interesting. I like short. You, well, you know, if it's not going to be short, though, it ought to at least be interesting. Don't go away. We got it. Excuse. The next is case number 2020-86. Could we please have a report by the investigators on this?
Sorry.
Oh, I'm sorry, this is continued. Didn't I continue this, Alex? No, 2020-86. All right, so that has been continued to the next meeting. So the next is 2021-20, Fulton County poll watcher issue. All right, can we hear about this case, please?
Yes. Robert Sinners and Michael Proenza, both certified poll watchers, both filed affidavits indicating that they arrived at a polling location at the Buckhead Library October 12, 2020, when they observed a Democratic poll watcher using her cell phone and iPad inside the polling location. They indicated that 2 of the poll watchers were inside the location and 1 was in the voting area, sitting at the voter check-in table. This poll worker was recording and taking pictures. They approached the poll manager, Kate Daniels, and presented their credentials. However, they were not allowed to enter and were told that since 2 poll watchers were already there, they would not be allowed to enter. Mr. Sinners told her that he would not be on the poll watchers list as they received their commission from the Secretary of State pursuant to Georgia Statute 21-2408, and that statute allows for 2 statewide poll watchers in addition to those on the county-appointed list. After some checking, the poll manager said that only 1 of them would be allowed inside. They repeatedly implored the poll manager to read the statute, which would inform her of the legality of their presence and the illegality of the Democratic poll watcher using electronic devices in the polling location. The poll manager told Sinners to stop speaking to her, and she walked away. They departed, that is, Sinners and Proenza, approximately 45 minutes after their initial arrival. Investigator was able to speak with the Democratic poll watcher in question, Tony Staple, via telephone. She admitted to having her iPad and using her phone. She stated she did not know that she could not use her electronic devices. When she arrived, she was told by the poll manager that she was not inside the enclosed space. When the GOP poll watchers arrived, they told her that she was inside the enclosed space. At that time, she put away her tablet. She denied taking any photos in the polling area. She told the investigator that the poll watchers were rude and abrasive to the poll manager. She indicated that she was 12 feet away from the voting machines. Her understanding was that she could legally be there. However, due to the confusion, the poll manager told her to leave the room if she wanted to use her phone. The investigator tried to set up an in-person meeting with Ms. Staple. However, he received an email from the general counsel of the Democratic Party indicating that if he wanted to speak with Mrs. Staple, he should contact him first. This attorney also indicated that Mr. Centers and Mr. Proenza were rude and aggressive toward the poll manager. The investigator tried to interview the poll manager, Kate Daniels, on the scene that day. However, it was too busy. He gave her his business card. She said that she would complete a statement. She did not contact him. He returned later and spoke with her a second time at the polling location. She again indicated she would write a statement. However, she never did. He also emailed the Fulton County Election Office asking for contact information for Ms. Daniels. However, they never responded. So ultimately, the findings was there was no evidence to suggest that Tony Staple was using electronic devices or taking photos within the enclosed space. There is evidence to suggest that Mrs. Daniels did not allow Mr. Centers or Mr. Proenza in the precinct at the same time as the poll watchers. And Mrs. Daniels unfortunately never responded to the investigator to give her version of events. So in looking at this, this would be suggested violation of OCGA 21-2408 sub 3 sub A.
Is someone from the Fulton County Board of Registration and Elections or is poll manager Kate Daniels the respondents here, and do they want to respond?
Can you press the, you see the talk button?
Good afternoon. You now? All I remember since this is from year 2020, is that two young men came into the Buckhead Library and told me that they were poll watchers. I asked them for their letters, and they did not produce one. They were intimidating and arrogant, so I called the Chief of Elections, Mr. Dwight Brower, and asked him if they have letters from the Secretary of State office. So I asked them again if they had a letter, and I was then shown both letters. Mr. Brower advised me that it was okay to allow them to stay. I then told them that one could observe from the lobby and one could stay inside. This is due to COVID-19 in a very small location. They insisted that they both could stay inside, so I gave them the opportunity, and both stayed inside shortly after they left the Buckhead Library. I apologize for not responding due to a serious accident that required medical attention, and I'm still trying to recuperate. Kate Daniels. May I also add a statement from Fulton County in regards to this matter?
Yes.
I would like to add that our county welcomes public observers and poll watchers to observe our open and transparent elections, and we train our poll managers to do so per election code guidelines. Because of the numerous reports we received from our poll managers in 2020 that poll watchers were attempting to intimidate and distract them, and or would not provide credential letters and badges as required, we actually drafted a poll watcher and public observer guideline flyer outlining the protocols poll watchers and public observers and poll managers are to follow. We forwarded that flyer to the SOS for approval, and upon approval, we provided the flyer to the political parties in hopes they would distribute this information to the poll watchers. From Ms. Daniels' statement, I believe she followed protocol when she received both their credential letters. Therefore, we ask that this case be dismissed.
Great, thank you. Any comments or questions by the board?
Questions to the investigators,
You may.
Did the poll watchers have credentials?
The Mr. Centers and Mr. Proenza?
Yeah,
Yes, yes, sir.
okay.
They were on the list.
They were on the list?
Yes, sir.
Thank you.
Is there a motion?
I've got a quick follow-up question. Sure. Do you know whether they were actually wearing their badges when they came, or did they just, is that indicated in the investigation file? Having served as a statewide poll watcher, they're given badges to actually wear in addition to their letters. to make it obvious.
They both filed affidavits. I can try to look at them real quick and see if that's mentioned.
These are on page 6 and 7.
Yeah, it just says, yep, credentialing letters to the manager.
Yeah, there was nothing in the affidavits that I recall that said that they had credentials, that they just said that they had letters and that they wouldn't,
Yeah.
she would look at them. But that is a standard practice, isn't it? That if you are permitted, that one of the reasons why they do that is to let everybody know that you have a right to be there.
Exactly, exactly. And I think that's one of the important lessons here is that we're going to see this again. You know, we're going to see lots of very engaged, interested poll watchers, and they're a critical part of the process. But they have duties, and one of those duties is when you're given a badge, make sure you're wearing it so that voters understand what your role is. And they are not questioning voters as well as poll workers. And it's a responsibility. In fact, we have the responsibility, and I think there was, SB 202 included additional training requirements and certification requirements on the part of poll watchers. And I think it's incumbent on us to review those and make sure that that includes a reminder that all of the credentialing is used properly by the poll watchers.
And who does the credentialing?
Each county, well, for the specific county and assigned ones, the political parties
Right.
identify, send those credentials send the names to the county supervisors, and the county supervisors provide the badges.
But I
For
think
the
for state
statewide,
still,
for the
yeah.
statewide, it's the Secretary of State's office. And there's a longer lead time. That has to be 3 weeks in advance or something.
If I may ask another question to
You
the
may.
investigator. How long after this incident, I think I know the answer, I just want to have this confirmed. After the incident, did you talk to the two poll watchers?
Yep, 7 days. October 20th, it looks like,
7 days.
from October 12th.
And now we
Eight-
have
8 days.
the respondent poll worker 2 years later. And as you point out, her recollection is not too good now because 3 years later. And that the only reason we have that recollection because of 3 years later is that she didn't come and talk to you when you first asked. And so, a fundamental principle when it comes to witnesses is that your memory fades. And so I tend to want to listen to folks who give a statement within 7 days versus someone who gives a statement 3 years later and doesn't provide it to the investigator until the day of the hearing. So, to be honest with you, the 7 days has more weight. And that's sort of a cautionary tale to my friends at the very county level. If you've got a witness, to the investigator immediately, do not let time lapse. Because we're going to be listening to those often being equal to someone who is prompt in terms of immunity versus someone who delays for an extended period of time. Number two, while we can't tell the level of rudeness or not rudeness, certainly would always prefer poll watchers to be polite. But you deny me the right to something that I'm entitled to it, I might get a little irritated. So I want to make that observation as well. Based on the evidence evidence, they had at least the letters. They should be better if they had the hotel as well, but they had the letters. They were denied when they were entitled. So, I think that we need to be considering that heavily. And the chief witness, in terms of respondent, waited 3 years to come.
Is there a motion?
I move that we refer this to the Attorney General.
Is there a second?
I'll second.
It's been moved and seconded that a violation be found and that it be referred to the Attorney General's office. Is there any further discussion? There being none, we'll vote on the motion. All those in favor say aye.
Aye.
All those opposed, no. The motion carries unanimously. I do want to, in this report, there is something that concerns me a bit. This is a kind of a lawyer thing. There was an email that was sent by the General Counsel for the Democratic Party in which he made this statement. This was to the investigators. I'm General Counsel of the Democratic Party of Georgia. I understand that you are conducting an investigation relating to the Buckhead Library early voting location that may involve the conduct of one of DPG's, Democratic Party of Georgia's, poll watchers at that location. I also understand that you spoke with one of DPG's poll watchers at that location. To the extent that you did not know that DPG is represented by legal counsel, I'm informing you of such. Therefore, if you wish to speak with any DPG employee, agent, and/or designated poll watcher, please let me, Matt Weiss, DPG Deputy General Counsel, copied know, and we will assist you in facilitating that conversation. What bothers me about this is to say that anybody who is employed by you or your agent, that you have to contact first counsel for a party seems to me to be a deterrent to investigators doing their job. And I don't know, I've got other lawyers and Dr. Johnson, I don't know if you share that same feeling, but I do want the investigators to know that they are entitled to do their job thoroughly. And that every time that they talk to somebody, they don't have to ask whether or not they're an employee, agent, or designated poll watcher, and can't talk to them unless they contact counsel for the Democratic Party. That seems to me an overstep.
I would agree, and simply also, as a matter of instruction, I think if this lawyer simply said, to the extent that you need to talk to anyone, please let me know and I'll be happy to facilitate,
Yeah.
without some type of instruction, would have gone a long way. And quite frankly, that's a lot of times what lawyers do. Mr. Brown exhibited that today. I don't believe he ever tried to block our investigators talking directly to people, but he certainly facilitated getting information to us. That's how things should be done in terms of lawyers involved in these sort of matters should be helping to facilitate the investigator getting that information promptly. That would have been fine, but it's when you try to block the investigator's investigation directly, that's when you cross the line, perhaps.
Well, would any member of the board object to me writing to the General Counsel of the Democratic Party advising him that, wanted to make it clear that they had taken this position, but if they're represented and the investigator knows they're represented, that they can say that they're offered to help, but that they can't require them to go through the General Counsel's office?
I would not object, and I wouldn't even mind if you CC'd the Republican, because I got a feeling that we're going to have this come up next year. And I'd like the other party to also know you're not supposed, maybe send it to the Democratic one and CC it to the Republican one.
And the
Just-
Libertarian and anybody else?
And the Libertarian and any other council that we may
I'm
know,
happy
because
with
I
that.
got a feeling that we're going to hear about this quite a bit. And it'd be good if everybody understood the same rules of the road.
I will do that then, thank you. Unless anybody else has an objection. Okay. All right, then we are now on to case 2020-147, Paulding County absentee ballots.
Okay, so this complaint involves a number of allegations, all within Paulding County, a number of respondents. We'll start with number one, Audrey Taylor. She sent her absentee ballot on September 28, 2020. It was verified and accepted on the same day. She then shows up on October 26, 2020, and votes in person at the Watson Government Complex. She was later interviewed by the investigator, and she stated that she hand-delivered her absentee ballot and was told by an unknown female that her vote was not going to be counted. She also indicated that she received a letter stating that her vote was not going to be counted. Because she believed that her ballot was not going to be counted, she went and voted in person. She could not describe the female employee that made that statement to her, and she did not have a copy of the letter that she alleged was sent to her. She alleges that she turned the letter into the election office, and she also said that she did not believe that she was voting twice in the same election. Later, an email was sent to Paulding County Election Supervisor Deidre Holden requesting additional information, including any letter on file that may have been sent to Mrs. Taylor. Mrs. Holden replied by email that you will find the affidavit that Mrs. Taylor signed canceling her ballot on October 26, 2020. However, she had already sent her paper ballot in and it was processed during early tabulation. One of the early voting clerks went into ElectionNet and counted the ballot and let her vote on the BMD. Obviously, the clerk was not paying attention to see that the ballot had already been voted and accepted on September 28th. The registrar clerk on the application for official absentee ballot is April King. April King claimed that she did not allow Mrs. Taylor to vote in person, even though her name was on the absentee ballot application along with her initials. She claimed that she left her computer when she went to lunch and it could have been someone else. So that's the first part of it. The next, Brenda Johnson Mitchell.
Before you go on to that.
Okay, I'll pause then.
Since we have done this, multiple people yesterday in one of the complaints, I wonder if we ought to just take these one at a time. Okay. All right, does Ms. Holden or anybody else want to respond to the allegations as they relate to Audrey Taylor?
Good afternoon, members of the board. My name is Jason Phillips. I am counsel for the Paulding County Board of Elections and Voter Registration, as well as Ms. Holden. Bear with me, as sometimes my reading glasses don't make it as far down to this piece of paper here. This first allegation involving the one particular double vote, there's another one. They're very similar in regard, so I'd like to address, my comments are going to be addressed to both of those.
Who's the other one?
The other is I think we've got the
Brenda
two.
Johnson Mitchell.
Yes, we've got the two voters were Audrey Taylor and Brenda Mitchell. So as to these allegations, I think the bottom line is factually, we have two cases of double voting. There was a vote cast absentee, paper ballot. There was also a vote cast early voting in person. Factually, and I don't want to, just the bottom line here, we have two poll workers that didn't conduct themselves consistent with how they were trained. And as a result of that, we have a problem. Neither the Paulding Board of Elections nor Deidre Holden had any individual interaction with these voters. It was simply the actions of the two poll workers. What the board did do in this case, however, is that they have trained these poll workers on a process that is designed to prevent and prohibit this from happening. In fact, for the November 2020 election, our board did train 384 temporary poll workers. And as a part of that training, these poll workers were specifically trained that when a voter presents themselves to vote, you are to check their identification on the ElectionNet system. Once checked on the ElectionNet system, the system would indicate whether or not an absentee ballot has previously been issued. The training specifically at that point is if you see that an absentee ballot has been issued, those poll workers are to immediately contact the absentee ballot clerk. Once that contact is made, the absentee ballot clerk looks at what has occurred. The absentee ballot clerk will then make a decision. One, if that absentee ballot has not been accepted, then that voter who has appeared in person at that point in time will be allowed to vote. Cancellation would be occurring. If the absentee ballot has been accepted, the clerk would advise the poll worker that person may not vote in person because their absentee ballot has already been accepted. That is specifically how they are trained. Despite that training, and for reasons unknown, these two voters were allowed to vote in person. Had they followed their training, had they simply contacted the absentee ballot clerk as trained, no double voting would have occurred here. That's what these poll workers did. But as far as my two clients, Ms. Holden and the Board of Elections, what they did, they trained them in a way to prevent this from happening. During each day of early voting, there is a daily auditing process. During that auditing process, this scenario was uncovered. And what they did in response to that, as a board, as the elections director, they informed the Secretary of State's office. They self-reported that there had been an incident, and that brings us to why we are here today. In particular regard to these poll workers, we've got 384 of them. Every year that goes by, we get more poll workers. We train them as is our mandate. Yes, the board is their supervisor. But when they veer from their training, when they violate their training, problems like this happen. As a board and as an elections director, I would contend we've done as much as we can. We can't sit there and monitor each voter individually. The board knows that. That's not how this system is designed. I wanted to comment on something that Mr. Mashburn said earlier today. That's in regard to self-reporting. I've been in front of this board 3 times since I've been doing this since 2004. And what I found is that when we have a technical violation, we self-report, we get prosecuted administratively, hopefully not criminally. But we've self-reported this, and as I've watched these patterns happen over time, I think the right thing is to identify an error when it occurs, but also knowing that these things can ultimately travel down the road to an end possibility, being a criminal prosecution. There is some tiredness that's occurring in self-reporting. I don't want to counsel my clients not to self-report a violation, but in a scenario such as this, where my client has done all that I believe they can reasonably be expected to do, other than to process the voter themselves, it becomes a little bit onerous, and in some sense, they become disincentivized to report violations when a technicality has occurred, and we know we're going to be down here to be prosecuted to some extent for it. I just want the board to bear that in mind. I know every board is different, and we're glad to appear in front of you on this. I would ask, there are multiple respondents in this case. My two particular clients, I would ask that the case be dismissed. In a worst case scenario, I'd ask that there only be a letter of instruction to do all we can to prevent any future incidents of double voting.
Okay. Any questions for,
I have one question. First of all, thank you very much for coming down here. We learn so much more when we're able to have this sort of give and take, and hopefully it's instructive to not just you all and us, but also other counties that may be watching. There's one indication in the file that multiple poll workers were using the same login with an employee's password. And so therefore it was impossible to identify exactly who might have done this, because at least the report from Ms. King was that she was off at lunch when this happened, but the deputy registrar was using her login. Is that the standard practice?
It is not the standard practice, and I inquired of that myself. What I learned is that on this particular day, the poll workers that were supposed to log into the system, their ID and passwords, for whatever reason, were not functioning that day. So they had to bring in a full-time elections employee to get that precinct up and running using her ID and her password so that they could begin the voting process for that day. I will also say this: as I was preparing to appear in front of you all today, I asked about the investigator's note. Says this investigator was unable to determine which poll officer permitted an unqualified person to vote. Looking at that particular voter's absentee ballot, there are two initials on top of that ballot, SE. I've asked the staff who would SE be. They said that would correspond with a woman by the name of Charlene Ussery, who was a poll worker that day. I believe that was the poll worker involved in the Brenda Mitchell double vote.
Thank you.
And Ms. King was in the Audrey Taylor.
Were the poll managers or the administrators able to figure out what happened so that we don't see this happening again, where you have to use an administrator's login? Because I think it's very important that that responsibility and chain of custody is maintained, and that we know exactly who was undertaking what steps. So what assurances do we have that this shouldn't happen again, given all things being equal, and that as long as the systems are working properly, that we won't see this where we've got unknown users using
That is a
logins?
great question, which I don't have the answer to, but Ms. Holden, who's with me, may have that answer, and I'll defer to her.
The reason this happened was, it was one of the first days of early voting. And the system we used to work in, ElectionNet, could not handle the massive amounts of people signing in. When you have a line of people waiting to vote, they're getting very irritated. So the best thing we need to do was send Jessica, sign on those computers, and get these voters through. Now, that can't happen. With our new system, it requires two-factor. It's got to have their own personal login, and that's something that was put in, in place by our new system, Jarvis. We had that, in the past, but ElectionNet just could not support all the users that was signing on, and that's why that happened. But that can't happen anymore, thankfully.
Perfect. That's exactly the answer I was hoping to.
Okay, thank you.
Thank you. I have no other questions.
So, Ms. Taylor, the first person described, sent in her ballot on September 28th, and then she shows up to vote on October 26th. When did the office discover that she had voted twice? What was the date of of your recognition of that?
I think what had happened was we were in the process of doing the early opening as we can, and our absentee ballot clerk, she conducts audits every day to make sure we're balanced. And I think that when she went into the system, she saw that, wait a minute, Ms. Taylor's ballot has counted and someone has allowed her to vote early. So I'm going to say that it was found probably by the end of that week, which I think was the 27th, was the last day of early voting.
But the absentee ballots had already been processed,
It had already been scanned.
opened and scanned?
Yes, ma'am, not tabulated, yes.
All right, any more questions? It does look like we can have a motion that deals with both Ms. Taylor and Ms. Mitchell's incident as it relates to the claims against the county. And if you agree with that, would somebody please make a motion?
I'm going to move that we accept council's recommendation for a letter of instruction. And the reason why is because I want the county to be able to use it as a training tool and not to go to the employees and say, hey, we almost got in trouble, but our lawyer got us out of it. But rather, hey, we actually did get in trouble, so y'all need to bear down on this and do better, because I don't like getting in trouble. So that's kind of my spirit on this one. So I move that we issue a letter of instruction to Paulding County, and then we're holding up of what we're going to do to the double voters, right? Okay.
Is there a second? Okay, it's been moved and seconded that we find a violation but send a letter of instruction. Before we vote on it, I'll add this, that the letters of instruction will be different. They used to be pretty formulaic, but in this instance, I think I would specifically tell the county that we appreciated their self-reporting. The self-reporting is important to us, that while there was a violation, that this violation was handled expeditiously in the sense of us being able to decide it, and that we continue to encourage self-reporting. Because this was a double vote, it's a little more serious than some of the others. I will say that our practice in the past has been, we've dismissed some cases, but we've sent a letter of instruction because we realized there was a problem. We wanted to let people know that there was a problem. So we have adopted the model, and those were all self-reported cases. So if there is self-reporting, it is important to all of us and meaningful to all of us when that happens, and we've tried to ramp down the consequence of the violation, and in some cases dismiss it, but with a reminder that there was a problem. So that's what, just so that when you vote on this, that's what I want you to know what I expect to say when I send the letter. All right, any further discussion on the pending motion? Then with respect to these two, Ms. Taylor and Ms. Mitchell, as it relates to the county, all those in favor of the motion say aye. All those opposed, no. Passes unanimously. So now we'll go on to Ms. King and then Ms. Gresham. And by the way, I think we said we haven't addressed the people who engaged in the actual conduct, that is allowing the double voting, but that's because we don't know them. Okay. All right, could we do Ms. King?
Okay. There is evidence to suggest that April King violated State Election Board Rules 183, 114.09 sub 2, when an absentee ballot which has been voted shall be returned to and received by the Board of Registrars. It shall be deemed to have been voted then and there. No other ballot shall be issued to the same elector. Audrey Taylor voted absentee by mail. She was allowed to vote again in the same election at the Watson Government Complex on October 26, 2020. This was for the November 3rd, 2020 election. April King's name and initials are on Ms. Taylor's application for official absentee ballot as the registrar/clerk.
All right. Is there any questions on the April King matter? If not, is there a motion? Is there a second?
Sending April King to the Attorney General?
Yes.
Yes, I second.
It's been moved and seconded that we find a violation and refer April King to the Attorney General's office for further processing. Is there any discussion on the motion? There not being any, we will vote on the motion. All those in favor say aye. Aye. All those opposed, no. The motion passes unanimously. Now let's go on to Jana Gresham.
Judy Godfrey died on August 6, 2020. Her voted ballot was received by Paulding County on October 29, 2020. Her daughter, Jana Gresham, as assisting, was listed, her address was listed on the return address and on the front of the ballot. Our investigator spoke with Gresham and told her that her mother requested an absentee ballot on May 21st, 2020. The ballot was mailed September 18th, 2020. It was received by Paulding County on October 28th, 2020. Gresham stated that her mother was in hospice and there was a lot going on at that time. He asked her specifically if she voted her mother's ballot, and she stated that she did not know and that she did not remember. She stated that she knew her mother's wishes and she knew who she would have voted for. The signature on her mother's oath envelope and the signature on Judy Godfrey's oath envelope, application for official absentee ballot, and her Department of Driver Services appear to be similar. Judy Godfrey's vote was ultimately canceled, according to ElectionNet.
Any questions about this individual's conduct and the report of it?
I believe the evidence is sufficient to conclude that a violation has occurred, and I move to refer it to the Attorney General's office for further processing.
Is there a second?
Second.
Any further discussion? Yeah, I actually think that if you really read what was reported in the report carefully based upon what Ms. Gresham explained, to say that she can't remember, but then she says, I knew her wishes politically, I knew what she wanted to do, seems to have selective recollection that maybe that she in fact voted it for her mother because she knew what she wanted. Whether or not she did that because she wanted to honor her mother, or whether she did that because she wanted to take advantage of an opportunity is not material. But I do think that this is appropriate to send to the Attorney General's office. Any further discussion? All those in favor of the motion say aye. Aye. All those opposed, no. Passes unanimously. The next is 2020-179, which is numerous counties' deceased voters.
Mr. Chairman, can we take about a 2-minute pause? I've got a quick question.
From me? Okay, we'll take a 2-minute pause.
Let me ask you this, is it appropriate or not? Because the other female is just as guilty as April King. I don't know why he didn't write it up, and I caught it kind of late, you know what I mean? But she did the exact same thing with the other lady. So she's getting off scot-free. He mentioned it too, their attorney. She should. What's that? Because she's not even mentioned in the charges. The person he talked about, Sean Easterly, she's just as guilty as April King. It's an old report.
I mean, I can't catch all this stuff, but yeah, for, at least when we're reviewing now, hopefully we'll catch it.
I know. I mean, I caught it, but it was already, yeah.
I
So,
caught something in this one right at the last.
yeah. So, okay, we'll let it roll.
All right, we're going to come back to order, please. Let's wait until everybody sits down. All right. Yeah, we're going to do the individuals after we get through the county, rather than try to shift from individuals to county, to the entity. Okay, so. We do have the individuals, yeah, I agree. All right, before we go on to the next case, we've dealt with the county on the matter, which is 2020-147, but we still have the individuals who double voted, and can we take those as a group, do you think? No. Okay, let's start with Audrey Taylor. We know Audrey Taylor's, the facts involving her, because we heard those when we dealt with the county. Is there a motion with respect, first, does anybody have anything else they need from the investigator with respect to Audrey Taylor?
If I can clarify, Ms. Taylor signed an affidavit when she was at the polling location canceling her absentee ballot, is that correct?
Yes, but it had already,
Okay, so
Yes.
I move to dismiss any violation here because she thought she was following the correct procedures.
All right, so there's a motion to dismiss. Is there a second? It's been moved and seconded that the claims against Audrey Taylor be dismissed. Is there any discussion?
Just by way of a question, just making sure I understand, wouldn't that affidavit be her swearing that she hadn't previously voted? I'm missing something?
There's an affidavit canceling your absentee
Oh,
ballot.
okay.
If she thought that was accurate, if she is able to cancel the absentee ballot, she did not undertake anything that would have indicated to her that she was voting twice.
Thank you.
All right, there being no further discussion of the motion, all those in favor say aye.
Okay?
All those opposed, no. It passes unanimously. Let's go on to April King.
We did.
Okay, Brenda Mitchell, right? You did such a good job of summarizing Audrey Taylor. Could you do it for Brenda Mitchell as well?
Well, did Brenda Mitchell also sign an affidavit canceling her absentee ballot?
I'm going through it right now.
Okay, thank
just to
you.
see.
My recollection was that she simply forgot.
Yes, that's what it looks like.
Is there any indication in the file what the age of the voter was?
You're not suggesting that somebody older would be more likely to forget this?
Individual circumstances matter.
I agree.
Okay. Yeah, that's Ms. Taylor. Keep going here. '69.
Oh, so she's a spring chicken.
I believe, she's not here, I take it. I would move that we find a technical violation and send a letter of instruction to Ms. Taylor to make sure that she understands my, from my recollection of reading the file, both she and her husband understood that she inadvertently voted twice. That is a serious violation. I do not think that there would be any risk of it recurring, and I do believe it was entirely inadvertent based on my reading of the case. So that there was a violation. I don't see that justice would be particularly served by tying up the resources of the AG's office for something that I would not imagine recurring. So that would be my motion.
Is there a second?
Second.
Okay, it's been moved and seconded that we find a violation, but send a letter of instruction to Ms. Mitchell describing our understanding of the circumstances and that she couldn't remember whether she had or had not, but that she needs to be aware that she may only vote once. She can only vote twice, but if she did, she'd get in really bad trouble. No, that she can only vote once and that she needs to be careful in the future in making sure that when she votes, that she is not voted by absentee ballot.
That is consistent with the way we have handled elderly people who have forgotten in the past.
Yes. All right, any further discussion on the motion? If not,
I'll go along with that, but I worry that we send a message to all our voters that they can simply appear at the polls and see if they can vote twice and then just claim that they forgot. So understanding that she's not a spring chicken, I don't want to inadvertently send a message to our voters that this is permissible to try to do this. Thank you.
all right. Any further discussion? All right, all those in favor say aye.
Aye.
All those opposed, no. The motion passes 4-1. Okay, next is deceased voters, SB 2020-179. Sarah?
Yes, 2020-179, deceased voter fraud. The Secretary of State's office initiated this investigation following an allegation of deceased voter fraud by Fox 5 News, I-Team, and Fox 5 News. Fox 5 News received an email from an email address titled Donald J. Trump for President, Inc., alleging that deceased voters were used to vote in the November 2020 general election. Out of the 13 names provided, only one person was identified as a deceased voter who had a vote counted for the November 2020 general election after their date of death. It was determined that an absentee ballot application was requested and a subsequent absentee ballot was submitted to the Dade County Elections Office in the name of a deceased voter, Edward Squiat, based on a voluntary handwriting exemplar submitted by persons of interest. It appeared that Jeffrey Law's exemplars had significant similarities to that of the decedent's forged signatures on the absentee ballot application and oath envelope. Based on the significant similarities that the decedent's forged signature on the absentee ballot application and oath envelope and that of Laws provided on handwriting exemplars, there is evidence to suggest that Jeff Laws, an occupant of the residence where the absentee ballot was mailed, violated OCGA 16-9-121 identity fraud and OCGA 16-9-2 forgery in the second degree.
There are some unknown subjects, at least in my summary. It says that these false registrations are currently under investigation by Georgia DDS.
Yes, there was an additional 9 allegations that came in afterwards, and out of those, there were some that we found that DDS has an open investigation into that, the Department of Driver Services. Those were for the voter fraud cards. So they weren't used for any type of voting.
All right, then with respect to Jeffrey Laws, is there a motion?
I believe there's sufficient evidence to believe a violation has occurred, and so I move that refer Mr. Laws to the Secretary, to the Attorney General's office for further processing.
Second.
Is there any discussion? Of course, we don't know what,
I'm sorry, go ahead.
since we don't know exactly what Mr. Law's intent was, is this something that we should also refer to the appropriate district attorney?
That was going to be exactly my question.
Or then I would amend that we refer to the Attorney General's office and to the appropriate district attorney. Is there any discussion on that motion?
Just one question, Mr. Chairman. Should we ask our investigators to also investigate Dade County regarding their handling of the matter in terms of their voter list?
Sorry.
That's an interesting thought. Let's first deal with
No,
Mr.
we'll deal with
Law's.
this.
Yeah.
Okay, that's fine. That was simply just part of the discussion.
Is there any further discussion on the motion involving Mr. Laws? There not being any, all in favor of the motion, say aye.
Aye.
All those opposed, no. So back to you, Mr. Lindsay. What would we tell the investigators to investigate? What kind of?
In terms of the voter rolls and whether or not any of their procedures in terms of being able to catch this sort of activity was in violation of any of our rules.
But as I recall, there's only one person who was found to have voted after they were deceased, correct?
Correct. I think the reason that was possible, according to what, for the benefit of folks who don't have the files, this was the one case where list maintenance activities were not conducted in a way that ensured that a deceased voter was immediately removed. In fact, I was impressed with all of the other cases that were investigated where a voter just died in February, was removed, the registration was canceled in March, died in October, registration canceled in November. In this case, the decedent remained registered for 5 years, which indicates some sort of failure on the part of the county to appropriately conduct their list maintenance activities.
I mean, I think that would be appropriate to refer to the investigators to open an investigation with respect to voter roll maintenance. It's generally, but specifically, to remove deceased persons after their death. Does everybody concur that I should do that? I don't think I'm going to have to vote on that, but I will make that referral. Next, Jackson County Unlawful Assistance, SCB 2020-183. Ms. Ms. Goth, whenever you're ready.
Yes. According to the complaint, Jake Sherman posted on his Facebook page that he requested an absentee ballot to be mailed to his address, and his parents completed the ballot and returned to the election office on his behalf. During an interview with Jacob Sherman's mother, Samantha, she stated that she and Jacob completed their ballots at the same time. She did not complete Jacob's absentee ballot. She showed him how to complete it himself by allowing him to review her ballot. An interview with Jacob confirmed he posted the message to Facebook, but he claimed the statement was false, and it was his way of expressing his concerns about election security. During the recorded telephone interview with Jacob, he stated he was present when his mother completed his ballot for him, as he called out his selections. He then looked over his ballot and signed it and returned it. However, in his written statement, he stated he completed his own ballot and his mother only gave him guidance on how to fill in his choices. A review of Jacob and his mother Samantha's election records for the 2020 general election revealed Jacob's signature on his oath envelope was not consistent with his signature on file. His printed name and date on his oath envelope appeared to be the same handwriting as his mother's handwriting on her application for absentee ballot. There is sufficient evidence to suggest a Georgia election code violation occurred. There's evidence to suggest that Samantha Sherman is in violation of OCGA 21-2385, and that Jacob is in violation of OCGA 21-560, making of false statements.
Is there any further explanation that we would like from Ms. Goth? Is there a motion to be made? Oh, are you the respondent? Okay, come on up. Sorry, I didn't see you. I should have asked if you were here. I apologize.
Honorable members of the board, greetings and thank you for granting me this opportunity to address you today. I am the respondent in this case. Before we begin, does the board have my written statement in question in front of them? If not, I have copies.
Yeah, this is your statement?
My statement, my written statement.
Yes, can we see that, please?
Yes, sir.
Give me the name, I'll hand them out. Okay.
I wish to assert with the utmost sincerity that the written and notarized statement I provided to investigators accurately reflects the complete truth to the best of my recollection regarding my 2020 absentee ballot. I took it upon myself to make my own choices, casting my votes and signing my name in adherence to the oath on the envelope. Although my mother and I completed our separate ballots in the same room, I want to emphasize that our decisions were never influenced by one another. It was during this time that she demonstrated the proper method of filling in the oval on her own ballot, which I observed after already marking my own. So I took it upon myself to correct my ballot, but I firmly maintained that my votes were solely my own. Regarding my previous conversation with the investigator over the phone, I cannot recall the specifics of the exact statements I made. However, I distinctly remember the interview took place while I was under considerable stress and in an inebriated state. It is evident that my case summary, that I must have misspoken or misremembered certain details. Regardless, I should have requested to speak at a later time when I was sober and focused, enabling me to provide the investigator with accurate information. Furthermore, I would like to extend my sincerest apologies to the esteemed board and all the dedicated individuals involved in the 2020 Georgia election process for my ill-advised and arrogant post on social media back in 2020. My remarks, which expressed doubts about the integrity of the absentee ballot voting system, could not be further from the truth, especially in light of this hearing and the diligent efforts of the investigators, which exemplify the seriousness in which this state treats its elections. I would also like to apologize to my mother, who could not make it today. She's sick. Hope she gets better very soon. I apologize for involving her in this whole ordeal. I humbly ask the board to view this as a significant learning experience and consider leniency. I acknowledge the unintended effects of my actions may have had on the lives of my loved ones, and for that I sincerely apologize. I approach this situation with a genuine sense of reflection and understanding. I extend my heartfelt gratitude to all of you for your time and kind consideration.
Thank you, Mr. Sherman. You were in the Merchant Marines, is that right? Are you still? And where are you stationed?
Working overseas
At, oh, so you flew in to be here today from Seattle, Washington? Well, I appreciate your candor and appreciate what I think is a pretty transparent explanation of what happened. And I appreciate the fact that you undertook to come here and one, be present, and second, be present and say what you said. So why don't you return to your seats while we discuss this? All right. We've heard the report from the investigator and have now had a chance to hear Mr. Sherman's statement. We have a copy of it. Let's discuss this before we decide on the motion.
I'll just kind of give you my thinking on it. We've had a case very similar to this before where a Facebook page statement was false, and I remember my comment at the time was it's not against the law to lie on Facebook. And the remark from the audience was, well, that's a good thing for most of us because most people are lying on Facebook to begin with. So it kind of got a chuckle from the audience. So I would offer Mr. Sherman a choice, and that is if he'll post something similar to what he just read us, it doesn't have to be the exact words, I'm inclined to dismiss it. And if he doesn't like that choice, then I would be inclined to issue a letter of instruction. So that's just how I think about it. Throw it out there for discussion.
I have I would deal with it slightly differently. One, the problem is, if you posted something like this on Facebook, would they believe that?
Yeah.
In a sense, that strikes me as a little bit too much. I don't know. It doesn't seem right to what I think seems better would be for me to write him a letter as chairman of the board, explaining to him about the election system, the need in this day and age especially, not to disparage the system, and not because that could discourage people from voting. And it would be like, my sons are waiting, one of my sons is waiting for me back at home, who's come up to spend a couple days with us. He's a little older than you, but I'm certainly old enough to be your father, and maybe you'll put a letter like that in your file, kind of as part of your story, and remember it whenever you decide to do something as errant as this. And then I would move to dismiss.
I've got a little bit of trouble with this because we moved today to refer a virtually identical fact pattern to the Attorney General's office, wherein a mother either filled out the absentee application or the ballot for her son. And we dismissed it yesterday, reconsidered it today, and are referring it to the Attorney General's office. And there was a discrepancy in what was stated to the investigators and what she came and stated here. Just as there is a discrepancy in what was stated to the investigators and what was stated here. And to treat like matters in a like fashion, I think it is incumbent for us to be doing that and to treat like voters in a like fashion. I would not be comfortable with a dismissal in this case. And there's further, and again, there were discrepancies in the signatures as well, in both cases.
Mr. Sherman, can you explain the discrepancy in the signatures?
Yes, sir. So right here, I have my Georgia's driver's license issued in 2019. If you look at the signature on this license compared with the ones on my notarized statement back in 2020, you will see that they are similar but not consistent. I just have very sloppy signature, and I wasn't given any evidence on this. So would the board mind?
Hold on for a second. So was the signature on what? The application?
The ballot versus the signature in that Ms. Koth, isn't that correct? That the investigation showed?
Yes, it says,
Do you have a copy of the ballot signature in the file?
$183.
It would be the actual.
It says a review of Jacob and his mother's election records reveal that Jacob's signature on his oath envelope is not consistent with his signature on file. His printed name and date on his oath envelope appear to be the same handwriting as his mother's handwriting on her application for the absentee ballot.
And who made that determination? The investigator?
Yes. And she didn't fill it out saying that she
Do we have those documents so
assisted.
that we can make the comparison ourselves?
And that matched his recorded statement that she filled it out for him while he called out.
I'm sorry, can you?
It said in the recorded telephone interview with him that he was present when his mother completed the ballot for him. So all that matched his statement that was recorded.
While they're looking that up, on that other case, wasn't it that the mother voted the ballot? Oh, no, scratch that. The mother said she threw away the ballot, and then the ballot showed up getting voted anyway, and so her theory was that somebody dug it out of the landfill and voted it, wasn't that?
Yeah, it was an application, but there was a ballot they actually
So
talked about.
there was the application and an actual ballot, both things going on.
Yeah.
And that her testimony was that she threw it away, and that somebody, the best she can figure, somebody dug it out of a landfill and voted it.
Yes.
Okay.
Do we not have the file?
She's gonna pull it up, the digital copy.
case of River Group, we now continue.
Spot tab 11 is. Do you want to see this with me? So that's on the envelope, correct? That's okay.
Is that signature of the book? This is the signature process.
Yeah.
It's pretty consistent with that.
While they're looking, let me ask you a question. They indicate that you were here in Georgia when this ballot got voted. Is that right? You weren't off on deployment anywhere?
No, sir, I was home. I was 2020, COVID-19, dropped all the jobs. I was working part-time at a book packing facility. It was just a bad time.
So in most cases, you rely on an alibi and say, I wasn't there, but in this case, it's the reverse of that. I was here.
I was here,
Okay.
yes.
All right.
This is hers. Oh, I can't tell. No, it's the signature. What the investigator said was the signatures, not. Was the similarity in the signatures or the similarity in the
It's the handwritten part.
signature book?
Printed. Yeah, it's his printed name and date on his oath envelope appeared to be the same handwriting as his mother's handwriting on her application. So they're saying that she assisted in helping him write it out without saying that she helped him write it out. Like she didn't fill out the part saying that she helped him fill out his ballot.
But the signature is similar to the signature on his affidavit.
It just said that his signature wasn't consistent with his signature on file, not that it matched hers. They're just saying that the printed part was the same as her
I
part.
understand the printed part, I'm just talking about the key thing. Sorry.
Yeah, the
The
signature
key thing
part
for
was-
me is the signature. Is whether or not the signature on the ballot was consistent. And
It just said it wasn't,
Hmm?
it just said it was not consistent with his signature on file.
Yeah, the point, I guess my point is, his affidavit, at least my amateur view, appears to be consistent on the affidavit and on the ballot.
That's the way she signs.
Am I wrong?
No, come here and look at this.
Glasses, I can't see.
So if we're looking at signatures, that's the way she signs,
Yeah.
which is,
My observation is that his signature on the affidavit is consistent with his signature on the ballot. And for that reason, I would agree with the suggested motion.
and I would make the further point that the comment was made that the signature was consistent with his mother's signature. We've looked at her application, Silsworth application. That application, her signature looks distinctly different than his signature, and his signature on the, even on the document that he's provided today, is consistent with what was on the ballot. And do you have your driver's license? Somewhat different, but actually pretty close to what was on the, on file that they had for your signature when you had registered. Anyone want to see his driver's license? Oh, and that's, I don't remember anything about your personal identifying information. All right. So why don't you go back to your seat? Thank you for coming back up. So I can't remember which, I guess we started with your motion and then I had.
Sarah had an objection,
Yeah, but what was your, I'm just trying to remember what your motion was.
I was just thinking that,
Oh, yeah.
but I was focused mostly on the damage that was done from the false post and correcting that, but that's not what it was charged with. So my motion was kind of missed the target. So Sarah pointed out that she was troubled about what was actually charged, making a false statement to an investigator. So we kind of at Sarah's objection or statement that she was troubled that we were treating two similar cases differently. That's how I recall it, but Sarah, of course, could speak for herself. She's here.
You captured it very well.
She's never been unwilling to speak for herself, so. This is, if, we're trying to accomplish a lot of things as a new board. One is consistency. But the other is showing that we are very, we're focused on looking at what really happened, why did people do it, and showing that that we find ways other than approaching these formulaically.
If I may, Mr. Chairman, there are two issues here. One issue is, was there a fraudulent ballot?
And I don't believe there's evidence of a fraudulent ballot. Because the signature on the ballot is consistent with the signature on the affidavit that Mr. Sherman gave shortly after the election. So that's that. The second one is misinformation to the investigator. That's a lesser issue, but it's an issue. So I would prefer simply to do a letter of instruction on that issue. Just, you know, I have no problem, dismissing the ballot issue, but I don't want people to feel like they can make misinformation to them. But given the fact that the ballot's valid, I don't think we should go as far as sending it to the Attorney General for any kind of criminal thing. But I think a letter of instruction to the respondent on the issue of faults and on the need for candor and accurate information needs to be impressed upon him.
Of course, we still don't have a motion on that, but.
Well, I was going to make a substitute motion for that.
So let me first explain to Mr. Sherman. There are a number of options that we have. One would be to dismiss. One would be to find a violation, but not to refer it to the Attorney General's office or to anybody else. That you would get a letter from the board saying that you were instructed with respect to whatever thing we find the violation, but we're talking about not being candid for whatever reason that you weren't candid. You have an explanation for it. That explanation rings true with at least me, but you still need to have something of record saying that you have an obligation that when you talk to law enforcement or to investigators for us, that you have to be candid and honest and not mislead, even if that's done under the influence of a substance, that was wrong to do, and you would get a letter to that effect. So the substitute motion you would like to make, Mr. Lindsay, is what?
Would be a letter of instruction regarding the false and incorrect information provided and the failure to cooperate with investigators, focusing on that.
Is there a second?
Second. And the reason why the two cases are different now is because the voter appears to have voted his own ballot, and in the other case, it appears the voters
The
did
ballot
not.
issue that I want to send to the AG.
Yes. Agreed.
I knew Sarah knew that. I just want to make sure it's clear for.
Yes.
For me, I know, for me.
Listening audience.
So there's a motion to find a violation, but to send a letter of instruction to Mr. Sherman based upon his statements to and cooperation with the investigators.
Amend that, and to dismiss against the mother, right?
Dismiss against the mother.
Okay.
And to dismiss.
And to dismiss any claim regarding the false ballot. Yeah. Yes.
So that's the motion. Is there a second? Second. It's been moved and seconded. Is there any further discussion on the motion? All right, there being none, all in favor of the motion say aye.
Aye.
All opposed, no. It passes unanimously. Thank you, Mr. Sherman. We appreciate you coming down and I guess coming over from Washington. It was helpful to have you here, and I hope you'll understand our reasoning. You're welcome. The next matter to be heard is case number 2020-234, DeKalb County absentee ballot processing. Ms. Koth, we're ready. We're ready.
The Georgia Secretary of State's office received a complaint where an elector had checked his My Voter Page website and found out that the absentee ballot had been challenged and not counted. This occurred during the early voting for the November 3rd, 2020 general election. Mr. Allman said that the DeKalb County Board of Registration Elections told him that their records showed that he had early voted in person at a church precinct. He stated that he did not vote in person at the early voting church location and that his precinct is at a school. The election supervisor, Tiffany Gilbert, stated she personally looked through the absentee in-person applications for the date in question for the Berrien Christian Church early voting poll precinct and did not locate an application for Mr. Almond. Ms. Gilbert further stated because she did not find an application for Mr. Almond, she concluded that an error had been made at the advanced voting location. Ms. Gilbert also stated she did not feel that a thorough search was conducted. In summary, an unknown poll worker allowed an unknown respondent to vote in person during early voting for the 2020 general election at the Berrien Christian Church precinct using the identity of the complainant, James Doyle Almond Jr., at a search for the absentee in-person application for James Doyle Almond Jr. was conducted by the election supervisor but was not found. The unknown poll worker challenged the valid absentee ballot of elector Mr. Almond Jr., failing to notify him of said challenge and follow the procedures for a challenged absentee ballot in OCGA 21-2386. There is evidence to suggest that an unknown DeKalb County poll officer did fail to write challenge, the elector's name, and the alleged cause of challenge on the outer envelope and deposit the ballot of an elector in the secure sealed ballot box and be counted as other challenge ballots are. There is evidence to suggest an unknown absentee ballot clerk failed to notify the elector of said challenge.
And the violation claimed is what?
OCGA 21-2386, subsection 7, subsection E,
That's against DeKalb County's Board of Registration
and elections.
Is anybody from DeKalb County here?
Good afternoon, Chairman Duffy and members of the board. My name is Irene Vanderels, and I represent the DeKalb County Board of Registration and Elections. And we did receive notice that this case would be heard today, but the notice simply described in very general detail that an absentee ballot processing error had occurred during the early voting for the November 2020 election, but didn't identify the voter, the voting location, the date on which the alleged activity occurred. So I would ask the board, we contacted the investigator's office and they declined to provide additional detail that would help my client prepare a response to the allegations. And so we would request a continuance. I've taken notes here so that I can take this back to my client and confer with them. I understand that a statement was made, but as I'm sure you understand, there were many, many, many cases and investigations from the 2020 election. And so just based on the notice letter we received, we're not able to, recollect or collect any information that we could provide to you related to these specific allegations. So if we could be continued to the next calendar and hopefully get more information from the investigator, that would be helpful.
Who transmits the letters to the respondents?
I do that.
And did we just send this one paragraph summary to them?
I sent them the notification letter and the summary of investigation. That's all that I was told we're allowed or typically do send to respondents.
Well, my question was we just sent this summary of investigation that we have in our
That's all that
notebooks.
was sent.
Well, the summary of the investigation doesn't say anything. And we can't do this. I mean, we've got to provide more information about in the summaries, if that's what we're going to send, to give somebody on notice to say, oh, I see what they're saying happened on this date, involve these people, and now let us go and check and see if we can do an investigation. So I totally understand now, looking at this, that I think the error is on our part not giving instructions about how detailed these need to be for respondents. Unless anybody has an objection, we'll just put this off to the next meeting.
And now, just for the record, Mr. Chairman, I just want to recuse myself regarding DeKalb County.
Okay.
Yeah, Mr. Chairman, I'm looking at this summary of investigation, and this particular summary for this particular case, for this one instance, seems to be more devoid of information than they usually are. So I think this summary is the one-off as opposed to like all the summaries. I think it's okay that, as a general practice, that we send the summaries, but I think this one was the one most unhelpful out of the group, right?
Yeah, I agree with that. I'm really surprised that you couldn't figure out from this summary. Okay, we'll hear this at our next meeting. Thank you. Next is case number 2020-280, Morgan County Pictures and Polling Places. Sarah, we're ready.
This one has 3 allegations. They all involve 3 people taking photographs. Allegation 1 is Rosalind Hainmayer took a picture of her printed ballot and then refused to delete the photo after being asked to do so. Allegation 2 is Lori Michelle Frost took a picture of her printed ballot and then posted it on Facebook. Allegation 3 is Luke Wilkins took a picture of his printed ballot and posted it on Facebook. Allegation 1, the election director, Ms. Dorian, advised she told Ms. Hainmayer to delete the photo, which she refused. The investigator contacted Ms. Hainmayer and she advised her of the complaint. She was advised that she was unaware that taking the photograph was against the law. And the second allegation, Lori Frost put it on Facebook. The investigator attempted to contact her numerous times, which went unanswered. The investigator contacted her husband at their address, who referred the investigator to their attorney. Allegation 3, Mr. Wilkins also posted that photograph on Facebook. Mr. Wilkins was advised that he did take the photo, but did not know that doing so was against the law. He advised that he would not do so again. There was evidence to suggest that all 3, Ms. Hainmayer, Ms. Frost, and Mr. Wilkins, violated Georgia Election Code 212413 when they used photographic or other electronic monitoring or recording devices while such person is in a polling place while voting is taking place.
Is there anything further from the investigator that you would like to hear?
Just one, after they referred you to the attorney who refused to cooperate. Did the attorney ever cooperate with you?
Let me double check. Let me see. Yes, yeah, the lawyer contacted the investigator.
And what did the lawyer say about their client's conduct?
He said he reached out to the investigator, advised him of a federal injunction barring the state of Georgia from pursuing OCGA 212568.2. However, in that same case, it advises the following 212413.
So his position was that the investigator was violating a statute by questioning the photograph?
No, he was saying that Judge Mahoney's injunction on some other aspect of the photograph.
It was different.
This was a different statute.
Yeah, it just says barring him of a federal injunction, barring the state of Georgia from pursuing OCGA 212568.2.
It would appear that this lawyer wishes to run up his attorney's fees, and I'm going to give him an opportunity to do so in a moment by not cooperating. And at the appropriate time, I'm happy to make a motion as to all 3. I would move that the first, inconsistent with our other, in terms of the first and third allegation, that a letter of instruction that be sent to them. In regards to the second one, I would refer the matter to the Attorney General for further investigation.
And what's the distinguishing feature?
Was the first and the third were cooperative and were willing to work with our investigators and express regret for what they did. The second one refused to cooperate, and the lawyer refused to cooperate. So we don't know all the pertinent facts.
All right, it's been moved and seconded that we find a violation for Ms. Heinemeyer and for Ms. Frost, but that we send them a letter of instruction reminding them.
Wait, we have, no, Frost is the one.
No, that's correct, no. Ms. Hannemeyer and Ms.
Mr. Wilkins,
and Mr. Wilkins.
Ms. Frost had the attorney.
Oh,
Yeah.
yeah, or Ms. Frost's name is in allegation 3, I just misread that. So for Ms. Hannemeyer and Mr. Wilkins, we will send we'll find a violation and send them a letter of instruction, and we will refer Ms. Frost to find a violation and send it to the Attorney General's office. Is that correct?
Correct.
Any discussion on the motion? If not, all those in favor say aye.
Aye.
Opposed, no. It passes unanimously.
May I make a quick comment for any listeners
Yes.
in the listening audience? Many times people want to retain a copy. They claim they're taking photographs so that they can have a receipt of their ballot. There is a policy reason behind prohibiting that, and that is retaining proof of your vote allows for vote buying. It allows for fraud to enter into the system by showing evidence to an interested party and receiving some sort of remuneration in exchange for your vote. And that is the policy reason behind the prohibition against photographing voted ballots.
And regrettably, that happens, and the risk is real.
Yep.
Right, so that concludes our consideration of complaints. Our next order of business is to consider the Attorney General's report on matters that we have referred to the Attorney General. So, if Ms. Vaughn, if you could help us with that, we'd appreciate it.
All right, good afternoon. We have, coming from the Attorney General's office for matters that have been referred by the State Election Board, we have some proposed consent orders as well as a proposed final order. If it's the will of the board, I'll take each of these matters one at a time, if that would be preferable. The first matter that we have is a proposed consent order in State Election Board case number 2020-034. It's regarding the Montgomery County Board of Registrars, including respondents Bobby Carter, the Chief Registrar, and Probate Judge Ruby Sanders, the Election Superintendent. This came from the August 22nd, 2022 State Election Board meeting regarding a complaint that boxes of election documentation from 2013 and 2014 were not properly secured. During the meeting, the request was made with the vote for the referral to the Attorney General's office that the Attorney General's office tried to work out a plan for remediation with these respondents regarding the storage of records going forward. The attached proposed consent order includes a reprimand as well as an order to cease and desist. It includes a statement reflecting that effective January 1st, 2023, the new Montgomery County Board of Elections and Registration was formed, and that this newly established BOER is located in a new building that is equipped with cameras and has rooms with locks to secure and store elections materials, and that this building is not accessible to unauthorized persons. The Attorney General's office recommends that the board accept this proposed resolution as it provides, we believe, a response to what the board suggested at that meeting when the case was referred to our office, and reflects that new procedures have been put in place with this newly constituted board.
All right, is there any questions of Ms. Vaughn about the proposed consent order resolution?
I simply want to express my gratitude for the speed with which this is being done. This is one of the few instances where I have a direct recollection of the case itself, and now it's being resolved expeditiously, so I really appreciate that.
Thank you.
Thank you.
I do too. I think that when we hear something, we heard this in August, and to have this finalized just a few months after that, I think is a great confidence in the people that have to go through this system, that they don't have to wait forever for a resolution. So thank you.
Thank you.
All right, is there a motion to approve the consent order?
I so moved.
All right, it's been moved and second to approve the consent order. Is there any discussion? Seeing none, all those in favor of the consent order say aye.
Aye.
All those opposed, no. Motion passes unanimously.
Okay.
Next.
All right, so the next state election board case that we have, there are 3 proposed consent orders that we have regarding state election board case number 2016-110, 2016-110. This is regarding 3 individual respondents who were part of a broader discussion in an investigation involving Long County from the February 17th, 2021 meeting and the April 18th, 2021 meeting. I will start with the proposed consent order as regard to Harriet Smith. The proposed consent order provides for an order to cease and desist, a public reprimand, and a civil penalty of $1,000. Ms. Smith was bound over for violations related to her using her personal post office box as a temporary mailing address for absentee ballot applications for 20 voters during the Long County July 26, 2016 general primary runoff election. Given the age of the case, we do believe that this is an appropriate resolution. We think that it would guarantee results, and since the conduct occurred so long ago, it would be challenging to take it to OSA. Would you like to discuss Ms. Smith's consent order, or should I continue and discuss the other 2 individuals?
Let's take them one at a time. Let me note for those that are listening and that are here, that this case was opened in 2016. And so when Ms. Vaughn says it's been a long time before it's gotten taken care of, it's regrettable it's taken this long. It should not take this long, and it will not take this long in the future. So I do think that you use sound judgment when you look at things like that to determine what an appropriate resolution is, and we appreciate your sensitivity to that.
Well, we understand that. We're trying to provide the perspective that if it does guarantee a resolution in which there is a reprimand, a cease and desist, and a civil penalty that's guaranteed without the risk of a hearing.
And I'll say this about Ms. Vaughn. She has worked, she has been our lawyer now for how many months?
Oh, I started with the Attorney General's office in November of 2021 and just came into this role, I guess, in February, March. So it's been a pleasure to work for the board.
So it's that sort of attentiveness to the duties and her service to us that has been really, really impressive and has helped us manage our workload and get things done. So thank you very much, Ms. Vaughn.
Thank you.
All right. So is there a motion to approve this consent order? Second? It's been moved and seconded that the consent order involving Harriet S. Smith and SEB case 216-110 be approved. All those in favor say aye.
Aye.
All those opposed, no. Passes unanimously. Next.
Regarding the next 2 proposed consent orders for 2016-110, I'm going to describe them jointly because it's very similar conduct, and I think that's the most straightforward way to discuss them. So there was also a referral made to the Attorney General's office in relation to Brenda Velasquez Gomez and Yuritsa Velasquez Gomez, who were sisters and were foster children who were residing in Harriet Smith's group home. She was the respondent that we just addressed her proposed consent order. Ms. Smith's personal post office was entered as a temporary mailing address on the absentee ballot application submitted in regards to Yuritsa's name for the Long County July 26, 2016 general primary runoff election. That absentee ballot was not returned, but the investigator did find that Yuritsa voted in the November 4th, 2014 general special election as part of the broader investigation. Yuritsa told the investigator that her sister also lived with Ms. Smith, and the investigator pulled records for Brenda Velasquez Gomez. Those records showed that Brenda Velasquez Gomez voted in person in the July 26, 2016 general runoff election. Both sisters said they left Ms. Smith's home after they turned 18. Is expected that if these cases did proceed to an OSA hearing, both sisters would testify that they did not register to vote and that they did not vote, which is consistent with their statements to the investigator and their following statements. The proposed resolution for these individuals, for Brenda and Yuritsa Velasquez Gomez, is a $100 civil penalty each. Again, that would just provide for a guaranteed resolution without having to take this to a hearing, given the age of the case and the conflicting evidence that's presented. And the $100 civil penalty is lower typically than what would be suggested for a non-citizen voter, which was kind of the key issue to their cases and was part of their referral to the AG's office. But there's also evidence to support a finding, we believe, at a hearing that they were influenced by Ms. Smith. She was their foster guardian, and it's my understanding that within the investigative file, Ms. Smith was surprised that because they were legal non-citizens that they could not, in fact, vote. And so we recommend that the proposed consent orders regarding Brenda and Yuritsa Velasquez Gomez for $100 civil penalties each be approved by the board.
Is there any further questions for Ms. Vaughn on either of these two consent orders? Is there a motion to approve the consent order as it relates to Yuritsa Gomez and Brenda Gomez? Is there a second?
Second.
Been moved and seconded to approve the consent orders involving these two individuals in case number 2016-110. All those in favor say aye. Aye. All those opposed, no. Motion passes unanimously.
The next consent order is State Election Board case number 2021-181. And it also includes 2022-025, which was a duplicate complaint that was identified by the Secretary of State's office. The State Election Board voted to refer case number 2021-181 as it relates to the Fulton County Board of Registration and Elections and its former elections director, Richard Barron, to the Attorney General's office following the March 16th, 2022 meeting. The proposed resolution in this consent order is an order to cease and desist, and the Fulton County Board of Registration and Elections would agree to implement written policies and procedures for risk-limiting audits for all elections for which risk-limiting audits occur. The documentation regarding the written policies is attached as Exhibit A to the proposed consent order that has been provided to the board. We believe that this is an appropriate resolution given the findings of the investigation. The investigators concluded that the reported inconsistencies in this risk-limiting audit from the November 3rd, 2020 general election were the result of human error in entering the data that were not discovered in time to make corrections due to time limitations in completing the risk-limiting audit and the sheer amount of ballots, and not due to intentional misconduct by the Fulton County election staff. Furthermore, the discovered errors were a fractional number of the total votes counted and did not affect the result of the 2020 general election in Fulton County, which were confirmed as accurate by the risk-limiting audit. And as was stated in the investigative file, the purpose of the risk-limiting audit was to confirm whether the results of the original tabulation of ballots were accurate, which the audit confirmed. As I noted before, it was case 2021-181 that the State Election Board voted to refer to the Attorney General's office. And that occurred at the March 16th, 2022 meeting. On March 31st, 2022, there was an additional complaint that was received by the Investigations Division and was designated as State Election Board case number 2022-025. The Secretary of State's investigators made the determination that that complaint was duplicative of 2021-181, which had already been referred to the Attorney General's office, and so that file was sent over as well, and is included within this proposed consent order. As is noted in the consent order, Mr. Barron is no longer the elections director at Fulton County and would be dismissed as a result of the proposed consent order.
Any questions about this consent order and its resolution of 21-181 and 22-025?
Not so much a question, but perhaps a quick comment.
Okay.
If I may, Mr.
Chairman, this case and referral of the matter to the Attorney General is an example of what we're trying to do, and quite frankly, oftentimes trying to avoid doing. And you know, in terms of working with counties where there is an ongoing complaint, to see with the counties what they've done to fix a technical procedural issue before they come to us, before the matter comes to us, so that we can see that the changes have already been made, that the county's already working toward it, would have allowed us in March of last year to simply send a letter of instruction rather than sending it to the Attorney General's office. And I simply sort of raise this as not a precautionary tale, but as a tale to my counties that we're not looking to send matters to the Attorney General. That what we would prefer to do is see where there has been some type of error taking place, that the counties have undertaken affirmatively to fix the problem before they come to us, so that we can see that progress is made, and then we can deal with the issue at the hearing rather than having to refer it to the Attorney General. And that's all I want to say. I will make the motion, Mr. Chairman. I just want to encourage all counties to undertake that rather than have us send something to the Attorney General, then they come back a year and a half with exactly what we would have liked to see happen a year and a half ago. That's all. So, Mr. Chairman, at the appropriate time, I move to accept.
So it's been moved, and has it been seconded?
Second.
It's been moved and seconded to accept the consent order in these two cases. Any further discussion? There being none, all in favor say aye.
Aye.
All those opposed, no. The motion passes 4-1 with Dr. Johnson voting against the motion. All right, the next one.
So the final matter that we have for the Attorney General's report for today is a proposed final order, which would dismiss the respondent Maxine Evans in Hancock County 2017-081. Respondent Maxine Evans was bound over to the Attorney General's office following the State Election Board's February 24th, 2021 meeting. Ms. Evans had assisted 13 voters who were eligible for assistance in the 2017 City of Sparta municipal election, but the applicable code section at the time limited the number of persons an individual could assist to 10 in elections where there was not a federal candidate on the ballot. In 2019, the law was amended to revise and remove that restriction regarding the number of electors an individual could assist. Federal law provides that individuals who are eligible for assistance may be given assistance by a person of their choice other than their employer or the employer's agent or union's agent. As such, given this change in state law and the incongruity with federal law, we recommend the dismissal of these allegations that were referred as to Ms. Maxine Evans. There are still some other individuals who are, Ms. Aretha Hill in particular, who have been referred to the Attorney General's office under that matter number. That matter is still pending. This final order is proposed only as to the allegations for Maxine Evans to be dismissed.
Any questions of Ms. Vaughn on this proposed disposition? Is there a motion to approve the consent order? Second. It's been moved and seconded to approve the final order in SCB case 217-081. Is there any further discussion? All those in favor say aye. All those opposed, no. It passes unanimously.
Okay, and that is all that I had in terms of pending proposed consent orders and final orders. I did want to provide just a brief update regarding a pending OSA hearing. So for those of you who may be new to this process, if a state election board case is referred to the Attorney General's office and it cannot be resolved by a consent order or a final order, or it's just appropriate given the circumstances that it proceed to a hearing before an administrative law judge, we begin that process with the Office of State Administrative Hearings. We have such a hearing coming up on July 19th in Gilmer County regarding State Election Board Case 2016-070 regarding respondent Brian Pritchard. and that is following a referral from the State Election Board to the Attorney General's office at the February 10th, 2021 meeting. So just wanted to provide an update since that hearing is coming up.
Is it fair to ask for a 1 or 2 sentence summary about what that is about?
So the allegations are that Mr. Pritchard registered to vote and then voted while serving a probation for a felony sentence, I believe related to forgery.
All right, thank you very much, and thank you for the report.
Okay, thank you.
The next order. Next order of business is to allow people the opportunity to provide public comments. We have 17 people who have signed up to comment. The time limit is 2 minutes. And we begin with Judy Shiropoulos. Can you just turn on her microphone? You may speak from there. I'm going to turn your microphone on. You don't have to come up.
We can do that.
And you can sit down if you want.
There's a button.
Greetings, and thank you for the opportunity for public comment. My name is Judy Sofianopoulos. I have lived in Atlanta since 1968, and my current address is Kingsbridge Retirement Center at 3055 Briarcliff Road, Apartment 10, Atlanta, Georgia, 30329. I've been a voter for the past 7 decades, and I just want to say that I believe voting should be really easy for everyone. And I'm very grateful and appreciative that you all decided yesterday not to take control of the Fulton County Board of Registration and Elections. I've been a volunteer poll watcher and poll worker, and all the work that the poll workers do to provide smoothly run elections is one of the hardest jobs in the world, I think. And again, I think voting should be easy, and I think that we probably should do more public outreach and public information so people know what they're supposed to do. I'm all for more places to vote, more early voting, more drop boxes, more helpful information that gets out to the public, and especially extra help to people who need extra help, like young voters and disabled voters, like people that find themselves in the hospital when it's time to vote, and we need extra help for that. And that's about all I have to say, and thank you again.
Well, thank you for coming down. We appreciate your comments. Joy Wasson. You can speak from there if you want.
You see a little button that says talk.
Do you see a button that says talk?
Something's
Okay. Your mic should be active.
Hello, hello? Yeah. I'm Joy Wasson, a DeKalb County voter. Today's rules hearing and the SOS office report on the updating of software were illuminating. It was made very clear that our state, its counties, taxpayers and voters are not being well served by the current voting system. You punted on needed security rules and will have an advisory committee to consider some of the issues. This committee, in making rules and legislative suggestions, should consider the incredible expense in security, personnel, and logistical needs of such a mammoth system. Most other states more sensibly use ballot marking devices for accessibility only and use majority hand-marked ballots. There's no good reason for Georgia not to do the same, and I hope lawmakers hear these concerns. I'm very troubled that proper cybersecurity protocols are not in place, especially given the complexity of our system and its dependence on vulnerable devices. Please listen to experts for guidance in what urgent improvements are needed. Thank you.
Thank you very much, Ms. Watson. Liz Troop, or Troop, is it?
Yeah, I'm Liz.
Okay, sorry. One second, I gotta.
Sorry, I'm Liz Troop, a DeKalb County voter. Thank you for this opportunity to speak. Large institutions employ whole departments to protect them from cyber threats. They limit access to their software and limit their attack surfaces. They make sure personnel understand password protocols and spear phishing attacks. They regularly upgrade software. Nevertheless, some institutions do get hacked. When they do, they study what they overlooked and double down on protections. While probably no election system is 100% secure, they do not give up on attempts at security. It may not be feasible to mitigate all remote threats, but this does not allow us to dismiss likely threats. We cannot throw up our hands or equate paper ballots with ballots generated from vulnerable electronic devices. Different systems present different security risks, but we must always do our best to safeguard elections. Thank you for your service.
Thank you very much, Mrs. Troop. Eileen Nakamura.
Is this working? Do you mind if I sit down?
Nope,
I'm frozen.
Happy to have you sit down.
Thank you. Good afternoon. I'm Eileen Nakamura from Fulton County. First, I'd like to thank the board members for your service and your time to Georgia voters. I really appreciate it. I'd like to comment on a few things that I heard this morning during the discussions after the proposed cybersecurity rules from the Coalition for Good Governance and the Morgan County Dems. As well as the presentation of the Dominion 5.17 system. I find it hard to understand how the body that promulgated the rule that emergency ballots can be used when lines are too long, when lines are over 30 minutes, feels that it cannot add a few words to the emergency balloting rule to include cybersecurity threats or equipment vulnerabilities to the range of scenarios that can prompt the usage of emergency ballots. Does that mean that if actual malware were found in the system today and the state had no way to mitigate it, as we don't think it would, we have no legal way to switch to emergency balloting procedures right now? Unless the legislature were to make a new law about it. Instead, it seems the board feels that the best way that it can do whatever it can to respond to the massive breach that occurred in Calhoun County right now is to start a study committee. I hope that the study committee will act with the appropriate sense of urgency that the nation's top cybersecurity experts have been trying to convey to you in the Georgia Secretary of State's office, because the bottom line is our election system as it stands today is highly vulnerable to attack. Mr. Lindsay, you mentioned the study committee was important so that they could recommend rules should a catastrophic breach occur. But the experts are saying, and they're telling you, that the catastrophic cybersecurity breach has already occurred. We've now heard from the state that implementing the new Dominion System 5.17 will not only be very, very expensive, but we don't know if the vulnerabilities found by Dr. Halderman will be appropriately addressed by the new change. I hope the study committee will look at all the facts concerning the danger of Georgia's elections, concerning the danger that Georgia elections are in, and at this moment, take action to mitigate the situation by recommending that cybersecurity breaches and system vulnerabilities should be added to the list of instances that can trigger emergency balloting procedures. Thank you.
Thank you very much. Sylvia Albia.
Technology. Thank you for the opportunity to speak with you. My name is Sylvia Albert, and I'm the Director of Voting and Elections for Common Cause. Common Cause is a nonpartisan grassroots organization dedicated to upholding the core values of American democracy. Common Cause Georgia would like to offer the following testimony regarding the implementation of SB 222. SB 222 requires that all funding for elections be from funds appropriated by the state of Georgia or the federal government and closes off other sources. The language of the bill, however, does not provide guidance on the process of implementing the requirement, while at the same time including harsh penalties for violations by election officials. To properly prepare for the 2024 election, officials in all 159 counties of Georgia must have a clear understanding of what resources are available to them to run their elections and how they go about receiving them. Just some examples of the confusion over SB 222. The federal government is a major funder of election grants to local jurisdictions. While it is an acceptable funding source under SB 222, the bill also says that counties cannot solicit funds. So does that mean that they will be unable to apply for grants? Does that mean that the state is no longer going to use the federal government as a source for funding, or will the SEB be making application on behalf of the counties? And if so, what is that process? How do local election officials request that a grant application is made on their behalf? Without guidance, election officials around the state are paralyzed with fear of prosecution and unable to take actions to ensure they're able to receive the funding that is available to them and that should rightly be theirs. Further, if the SEB receives funding, how will it be distributed? Is it by need, by per capita? How will they be able to demonstrate their needs? Furthermore, the lack of clarity has also left election officials unsure of how to support each other. Previously, if they had excess materials, they could give it to a neighboring county. However, neighboring counties are not listed as an accepted source. So will the SEB be a middleman so that these materials can actually transfer per county? So these are just a few examples of some uncertainties that come from SB 222. So we urge you to promulgate rules or issue guidance on this around the administration of funds and establish policies so that these election officials will receive the funds that they need to execute the 2024 election.
Well, thank you. Let me give you two pieces of information. We filed a report right before the General Assembly on the distribution method that we are recommending to the General Assembly, so that's already been in the works and has been for a few months. And we are already discussing where there's excess material, how can that be done so that it can be moved from one place where it's not needed to another place where it is, and how we can do that within the context of 222. So we are already working on a number of those issues. Ted Metz. Okay.
He's not here.
Kristen Neighbors.
Is it working? It is, okay. Hi, my name is Kristen Neighbors. I'm the State Director for All Voting is Local. We're a nonpartisan organization that advocates for counties that will advocates for policies that will aid counties in running smooth elections. Today, I'm here to urge the State Election Board to issue guidance to counties regarding voter challenges. All Voting is Local has identified several reasons why we believe guidance would be impactful. First, the challenge procedure places a massive burden on election offices, often at peak times. I knew I wouldn't have long here, so I actually gave Alex a packet of some of the voter challenge coverage. There's 3 articles in there, but if I had to only pick one, it would have been the CNN piece, which asked Zach Manifold and Gwinnett about the time it took his staff to research the mass challenge they received last fall. Actually, there were 5 of our largest counties all held hearings in October or November last year while they were simultaneously running elections. It diverts staff capacity, often during critical periods. Second, county staff positions, of course, are funded by public dollars, which means there's a financial cost to these as well. When a challenge is submitted, the county election staff spends time researching the list and contacting the challenge voters. Even the hearings alone, because they set a hearing, and then the hearings alone use a significant amount of time. Just in 2023, there have been at least 9 hearings with challenges to more than 6,500 voters. One hearing in Gwinnett started at 6 p.m. and wrapped at midnight. So we have counted more than 120 staff hours in just hearings this year. This estimate doesn't include any of the research time or any of the outreach time. We didn't track the length of every hearing in 2022, but we do know it was a large number. There were more than 60 separate lists of challenges submitted last year, totaling more than 75,000 voters. Third, challenge lists often rely on outdated or unreliable sources. I've seen challengers citing research from qpublic.net, which is supposed to be tax records, and voteref.com, which is supposed to be voter registration data. Both sites state on their homepage that they do not guarantee the accuracy of their data. I'll pick it up. These sites don't include voter ID numbers. It's very easy to mix up voters with the same name. VoteRef also doesn't update in real time. The list they're using is from February 2021 and doesn't contain any updates since then. Challengers, we've seen challengers repeatedly challenging voters who've already been canceled or in the process of being canceled. So if the SCB was able to offer guidance on what kind of challenge evidence requires research by staff and what kind of evidence could be dismissed out of hand, it would really go a long way toward lessening the burden on the offices and also on the taxpayers. It would also decrease the likelihood that lawful voters would be disenfranchised. And finally, we would ask that you also consider a 90-day lockout period prior to an election, which is in line, of course, with the NVRA prohibition on systematic removals within 90 days. It would mean that challenges do not need to be adjudicated during the busiest times of the year. Thank you so much.
Thank you. Guidance on challenges has been in the works for about a month. We hope to be able to distribute that soon to the counties.
Fantastic. Thank you so much.
Mr. Chairman, can we also recognize that a young lady's been on the best behavior for 2 days here? And they're not.
Can you stand up? Can she please
stand up,
Can you
please?
introduce her for us or let her introduce herself?
Thank you.
This is my daughter, Matilda, who didn't have camp this week, so she's doing civics camp, social studies camp. Thank you.
And she's very shy. Good to have you. All right. Kelly Persons. So where are you, okay? Your mic should be live.
There we go. Thank you, sir. Thank you, Chairman, members of the board, for hearing our concerns today. I'm Kelly Persons with the League of Women Voters of Georgia. We're apparently in the advocacy row down here. So our mission statement is to encourage the informed and active participation of citizens in their government. We have volunteers that attend county commissions, Board of Education, and of course, local Board of Elections. First, we want to take a minute just to thank everyone. We know that elections are hard work, especially our county elections folks. So any opportunity we get, we want to raise them up. We do have some concerns about the rollout of the Jarvis system. We've received several reports from Carroll County, Chatham County, Columbia, Fulton, Gwinnett, and Rockdale about issues with the Jarvis system. Particularly that the data is unstable. There are voters that have been removed that reappear. The redistricting information does not always seem correct, and that there are, Several counties that are not able to put out their voter registration cards because they're unsure about the data in the system. So we wanted to highlight that and to also sort of implore the Secretary of State's office, the elections office, the vendor, and you yourself in your capacity to do what we can to fix this system so that our counties are actually able to utilize the database and be able to do the good work we want them to do.
Thank you very much. By the way, we've heard the same things about Jarvis and had an hour-long telephone conversation with Blake Evans about that the other day, and they are aware of it. And if you haven't heard, 2 nights ago there was a long list of changes and that apparently were rolled out to the counties, and we'll have to see whether or not that fixed some of the issues that people have had. Greg Landon.
Good afternoon, Board. Thanks for letting us have public comment here. My name is Greg Landon. I reside in Forsyth County, Georgia. The release of the Halderman Report was a shocking revelation to the many vulnerabilities that exist in the voting systems used throughout the state of Georgia. This damning report was suppressed by the Secretary of State's office for years, and we can all see now why he wanted that report never to see the light of day. Professor Halderman explains in plain detail how malicious actors can easily access these machines and alter the outcome of elections in our state. One of the conclusions Professor Halderman states is, I explain how such malware can alter voters' votes while subverting all the procedural protections practiced by the state, including acceptance testing, hash validation, logic and accuracy testing, external firmware validation, and risk-limiting audits. This is totally unacceptable. I'm appalled as a citizen, a taxpayer, and a voter in this state that this is allowed. The Secretary of State likes to tout the turnout and satisfaction of the public with our voting systems, but I ask, what choice do we have? These voting machines need to be immediately replaced with hand-marked, hand-counted paper ballots, serialized ballots on currency-grade paper. I would ask the board to use your influence to move in this direction of paper ballots as soon as possible. Thank you for your consideration on this critical issue.
Thank you, Mr. Landon. Frank Schneider.
Thank you and good afternoon. My name is Frank Schneider. I am a resident of Forsyth County, and I'm here to discuss my thoughts on the Halderman Report. My career is in finance and IT, including 5 years as an IT auditor. I've had a chance to read the entire report. I paid particular attention to chapters 8 and 9, dealing with unauthorized manual access and manipulation and remote access and manipulation. I read those a couple of times. My assessment of the report is that it is both substantial and damning. There are multiple points of entry to these systems and multiple ways to manipulate and overwrite files in order to inject code to do nefarious things. Greg referenced that as well. It is also possible to alter the audit logs so such activity can go undetected. We saw this sort of stuff in corporate system testing against potential attacks as well. When I look at this, this is almost like malware 101. I'll continue. Though Dr. Halderman acknowledged his report only picked out a handful of scenarios to evaluate and run scripted system hacks and penetrations against, there are likely many more that more sophisticated attackers could employ. In addition, the scope of his review and report were just the ballot marking devices and the printers. When you consider the scanners and the poll books, there could be many more areas of significant risk. I also had a chance to read Mr. Raffensperger's rather strongly worded reply to this report. It did little to address the issues brought up in chapters 8 and 9 or engender confidence an attack wouldn't take place either directly or remotely. Frankly, what I would have liked to have seen from his office is a moderate report that addressed the specific issues that Dr. Haldeman raised in his report, but instead we got this rather aggressive rhetoric. This is not going to blow over. Your constituents are focused, angry, and frustrated. They do not trust voting machines. All these recent events only provide further strong evidence that these electronic voting machines need to be done away with and paper ballots be hand counted and this process be reintroduced. We are working with our state legislators right now and through the judicial system to drive change. I'm not entirely clear what your legal authority is in this, but my hope is that you'll take what actions you can and give some serious consideration to this information that we now have. We need some thoughtful action. Thank you.
Thank you, Mr. Snyder. Eric Christian?
Eric Christensen, DeKalb County. I'm a former auditor with Arthur Anderson and a former systems consultant with Deloitte, and I presented at the last meeting. And I'm a little disappointed, I guess. I thought you guys had more power than you have, and hopefully the General Assembly can grant that to you, because you should have the plenary power under Article 1, Section 4 of the Constitution to set the rules and tell the Secretary of State how you want things done. Now, all is not lost. You hear about hack, vulnerabilities, all that kind of stuff, and that would be true with any system that we have. There's no perfect system out there. There's no perfect process. There's no perfect people. That's okay. We can deal with that. But uniformity is something that is required, I guess, by the Supreme Court, and that's something that we don't have right now. We kind of have it at the precinct level, I would say. We certainly do not have it at the absentee ballot level. We basically have two types of ballots. We got precinct level ballots. We've got absentee ballots. Okay, so what is the solution? The system, as it exists today, is not auditable in any way, shape, or form. You can say we have a risk-limiting audit. We don't have a risk-limiting audit. We've never had one. Putting in some simple procedures using the existing system today, we don't have to throw the baby out with the bathwater. We can use Dominion. I believe Dominion will work properly. Can it be hacked? I'm sure it can be. But if we do two things at the precinct level, one is we turn on the numbering system for the ballot marking device. Supposedly the ballot marking device will allow a number to be put on it. That would prevent ballots from being double scanned. We saw evidence that ballots were double scanned in the last election. That's probably number one. And number two, and I've given you guys a write-up in this, I'll do a full presentation at the next meeting, is print 2 copies off the ballot marking devices. Okay, so one copy gets scanned in the Dominion scanner, the other copy gets dropped into the audit bin. Everybody's familiar with carbon copies. We've been using them for 100 years. Everybody's familiar with audit copies. You see them at hotels. They give you copies that say audit copy on it. That goes in the audit bin. Okay, so can they still cheat? Yeah, they can. If they are cheating, we don't have evidence of that per se, but they will get caught because the audit bin will have a copy that will be handled by a different logistics company, and can be an auditing firm, it could be a lawyer, it could be anybody that holds those until after the election's over. We can go back and verify it later. Won't slow down the election, don't have to throw anything away. We can use the existing process that we have today. Absentee, I've got a much longer presentation. Don't have time for that.
Thank you, Mr. Christensen. Julie Adams. Can you press your button? It's the one that says talk. Okay.
It doesn't say talk, just thought I'd tell you that. So I'm a Fulton County resident, and I was this morning at the Fulton County Board of Commissioners meeting. I'd like to tell you guys what's going on there. I understand, I'm pretty sure you guys already have a complaint about this situation. So in Fulton County, our Board of Registrations and Elections members, the chairperson is chosen and nominated and appointed by the Board of Commissioners, and each major party gets to put forth 2 nominees that shall be appointed by the Board of Commissioners. A lot of debate on how this is worded. I know you guys have it in your complaint that you got, which I believe was yesterday, it could be today. But from what I understand from every attorney I've talked to, the way the code is written, the Board of Commissioners is to approve the nominees and put them on the board. As has been the case for over 10 years, I've gone back through the meetings, which was a very boring process, and found out that not once has any commissioner in any party voted no for any nominee. So we have, there's a nominee, and his name is Jason Frazier. He's very highly educated. He's an engineer, he's got an MBA, he's got a great work background. He's a great family man, and he started about a year ago cleaning the voter rolls in Fulton County, as SB 202 allows. One of the things that's the problem with the voter rolls, which it shouldn't really matter what his background is, I think the law is clear that the nominee should be appointed. But I do want to tell you one thing about Fulton County's voter rolls. Fulton County currently has a voting age population of 758,000 people. But currently, our voter rolls have 880,000 people that are registered to vote. Those people could walk into a polling location at the next election and vote. So typically, 65 to 70% of the voting age population of a county is registered to vote. But we have in Fulton County 122,000 more people registered to vote than are at the legal voting age in Fulton County. It's a problem. It is a serious problem. So Mr. Frazier has spent hours and hours for the past year working on the voter rolls, helping Fulton County with the voter rolls. And for this, he is not getting voted in as a BRE member because they say he's not serious. They say he's a disruptor. What I'd like to say about the disruptor is he's very mild-mannered in the first place. But 95% of his challenges have been approved by Fulton County elections. So, I mean, I just have a real problem that they're not putting this nominee through, and would really, really like to ask you all to really take a look at the complaint in this matter, because the new board members all go into effect July 1st. And I feel like this is very partisan, and you know, I would defer to you attorneys that it's not legal. So I would appreciate your consideration. Thank you.
Is there litigation filed challenging this? No.
I understand that there was a letter sent. Today was the second vote, and there was a letter sent to try to avoid that, but I'm assuming that litigation will be filed. And, you know, personally, I appreciate all you attorneys, but, you know, if it gets to that, then it's probably going to be, what, 25 before it's... I mean, I don't know, but I think that it needs legal consideration now, and I don't know how you guys stand on what your power is with that.
Well, thank you. There's been a number of articles in the paper about that. And at least I was aware of it. I'm sure everybody else was.
Right.
But thank you very much. Gail Lee. Okay. You're on.
You're on.
Hello?
Hello.
There we go. My name is Gail Lee. I'm a resident of DeKalb County, and I have two concerns that I'm bringing. First, the absentee ballot application is inadequate to deter fraud under the current law. It asks for the elector's registered address, but the form does not ask if the elector has moved from that address or for a current residential address and its effective date. So if an elector is on the inactive list due to a NCOA report of their having moved, they can enter the registered address as required, obtain an absentee ballot, vote, and be returned to active status. And this defeats the removal process. At the bottom of the form, the elector affirms that the information given is true, and it truly is their registered address. I believe the form should ask whether or not the elector still resides at the registered address. If the answer is no, there should be a place for their new address and its effective date. Failure to answer should result in no ballot being sent. My second concern is the lack of consistency among the counties for handling common issues and citizen challenges to electors. And I recommend that this board provide guidelines to the counties on basic issues like post office and UPS addresses, criteria for removing challenged electors reported by the NCOA system, missing dates of birth, commercial addresses, and missing and incomplete addresses. Several examples are: DeKalb won't remove electors with post office and UPS addresses for a residence. Gwinnett will remove those who have no other previous address. Currently, Fulton notes them as challenged and they remain active. Fannin removes them if they don't provide a valid address after notice. For missing dates of birth, DeKalb and Fulton leave them active, despite it being required for identity. Fannin makes their voting provisional until the date of birth is provided. And you have the rest. Oh, okay. To remove challenged electors reported by the NCOA system to have moved to another state, DeKalb requires direct notice from the Foreign Secretary of State. Fulton and Cobb require proof of voting elsewhere. Gwinnett requires proof of registration or voting elsewhere. Commercial addresses in Gwinnett will be removed. Fulton will note them as challenged and leave them active. Fannin will investigate to make sure there's no apartment at that location before removal. Incomplete addresses in Fulton are noted as challenged and left active. Fannin requires them to vote provisionally. I rest my case.
Thank you very much. Elena Marin. Marina, I'm sorry.
Hi, this is my first SCV meeting. I've been avoiding it on purpose. No. As you know, Mr. Duffy, I've been researching Dominion versions, testing labs, certifications, advisories, all this for about a year. For partly personal reasons. I had a friend who was an ex-spoke at the National Press Club about this. He's Latino like I am. This has been happening in Latin America for decades. So while it's new to the U.S., it's not for us. And he spoke about it, wrote about it, but anyway, I started doing research online, and I've sent you all the links of where I find things. But looking at the EAC database showed that we had 5.5A, Well, that's the version that the CISA, the famous CISA advisory on June 22nd was about. I quite didn't believe that we were still using that because I knew that they had approved B, C, and D. So I said, well, maybe EAC is just not up to date. So I spent a month back and forth with the Secretary of State open records request, asking for the last testing and certification of voting machines in Georgia. That was a struggle. This was before the 2022 election. Finally got it, and lo and behold, confirmed the last certification and testing of machines in Georgia was in 2019. I pulled our agreement. The Dominion agreement very specifically says if contractor makes any revision, modification, enhancement, improvement, or otherwise updates the software, patches, upgrades, it goes on and on. Such revisions must be provided by contractor on a no-charge basis. Somebody said it'd be expensive. No, no-charge basis. And what's even worse is that advisory on CISA states, Dominion acknowledges the issues, by the way, on that CISA advisory, and it basically says that, oh, but these have been addressed in subsequent versions, okay? So what version, the B, C, or D we ignored, or the 5.17 we're going to ignore? Just so you know, I mean, the bottom line is I did a lot of research in the last few days because the excuse is so lame. And I think that's the last email. I think I emailed back to all of you on May 22nd of this year. I kind of gave up. But we're going to be doing health checks. We got nearly 20 months, 18 plus months. We're going to be doing health checks. And we can't insert a USB to update the system? That's just, sorry, that's just not credible at all. So I went on to Secretary of State. I know I have a database on what states, what country, I mean, what countries, what counties used Dominion, and I went into 3, and all 3, in the first 3, I've only gone through 3, was Florida, California, and Michigan. Guess what? They all have time to update to 5.17. They, in fact, will not accept an earlier version of Dominion. That's Florida, California, and Michigan. Matter of fact, Michigan has a municipal in August, and they said they're hoping they can get it updated by August, but probably won't happen. Anyway, then I went to the EAC, and I got a cut, I guess, right?
Yeah, well.
But I went to the EAC, and lo and behold, all of Iowa that uses Dominion, those have all been already updated to 5.17 and reported back to the EAC. So this is a game that we don't have time.
He needs to give you 30 seconds.
That's basically it. I can go on and on, but
I know that was what I was
thank
afraid
you
of.
for your time.
Thank you, Ms. Marina. All right, that's the last person to make public comment. There's nothing else on the agenda for this evening, so I would entertain a motion to adjourn.
Second.
Been moved and seconded to adjourn. All those in favor say aye. Aye. Opposed, no. We are adjourned.